Good morning, Mr. Chairman, members of the board, those in the room, those watching on Charm TV. The May 21, 2026 proceedings of the Board of Liquor License Commissioners for Baltimore City will now begin. Please take this opportunity to turn off or mute all electronic devices. Do not be the person whose phone goes off in the middle of the hearing. The board is now in session. Just a few preliminary matters. Case number 20, 21, and 23 were postponed and will be heard at a later date. If you're here for a particular case, please make sure you've looked at the docket on the exterior of this room to make sure your case is being heard today. We have a lot of people, it appears, who aren't here regularly. When you come up to the lectern, please make sure that you speak loudly into the microphone so that we can make sure that people at home can hear and that we're making a good record. All right, here we go. In accordance with Section 12-2105A of the Maryland Alcoholic Beverages and Cannabis Article and Liquor Board Rule 2.16, the following licensee has participated in the monetary penalty in lieu of hearings program by voluntarily admitting the violations as charged and paying the corresponding fine. Vernita Jean Blackwell and Rishi Sharma, New RNJ LLC, trading as New Burgers One Tavern, 5523 Bel Air Road, Class BD7 Beer, Wine, and Liquor License, Rule 3.092 for on February 28, 2026, and violation of Rule 3.082 on February 28, 26, excessive trash. They paid a fine of $1,000. Krista Ann Cushman, Mickey's Joint LLC, trading as Mickey's Joint, 5402 Hartford Road, Class B Beer, Wine, and Liquor License. Request for a hardship extension under the provisions of the Alcoholic Beverages and Cannabis Article, Section 12-2202. Please come forward.
For the record, Melvin J. Cananci representing the licensee. This request, I think, was pretty obvious. They had a fire there, and they're trying to rebuild, and I think the landlord may even put the place up for auction, so she'll see some additional time.
Any questions, Commissioners?
No questions.
No questions.
Based on the March 30th letter and the proffer made today, I vote to approve this 180-day hardship extension of this Class B beer, wine, and liquor license.
I concur with the chairman. Based on your written request and information provided today by council, I vote to approve this hardship extension for this Class B beer, wine, and liquor license.
I will also approve the hardship extension based on the written request and the proffer made by council for the extension of this Class B beer, wine, and liquor license.
Ms. Russell.
No exhibits for the record.
Bijou Penland and Blanca Pesquera, New Ecstasy Bar and Restaurant, LLC, trading as My Cousin's Place, 3925 through 27 East Lombard Street, Class BD7 Beer, Wine, and Liquor License. Violation of Rule 3.02A, cooperation as of October 17, 2025, failing to satisfy fines for failing to maintain workman's compensation insurance for covered employees as required by Maryland Code Labor and Employment Section 9-402. Please come forward.
Once again, for the record, Melvin J. Cananci representing the licensee. I have a preliminary on it.
Go ahead.
Actually, the assessment is against Ecstasy Bar and Lounge LLC. This is New Ecstasy Bar and Lounge LLC, which was transferred in 23. The old company is out of existence, so it would be inappropriate to go forward against the New Ecstasy because they are not the entity on which the assessment was filed against and which the order was filed against.
Is it the same ownership, same everything?
New Ecstasy Lounge LLC is the owner. Ecstasy Lounge LLC, the LLC or corporation is the owner of the license pursuant to the case of Rosedale Plaza, went down to Court of Appeals. So
I need you to say the ownership of the entity.
it's the New Ecstasy Lounge LLC.
Can I just pause just for a moment, Mr. Chair? I'm sorry. Are both microphones on? Are there green lights on both?
Yes.
Yeah,
Okay.
you hear me?
Yeah, no, I'm getting a message that it's hard to hear.
So on the first entity that had the license was Ecstasy Bar and Restaurant LLC, is that correct?
That's correct, and that entity has been dissolved.
Make sure I'm speaking close enough to the mic.
That,
And when did that entity stop having the license?
in August of 2023, according to your record, when it was transferred to the new Ecstasy Bar and Restaurant LLC.
When did that entity miss the hearing with workers' compensation?
That entity, according to their records, was in '24. The Ecstasy, which was, they were no longer a licensee at the time.
So you're saying that the issues that they had with workers' compensation was after they were a licensee?
After the license was transferred.
Transferred already?
Yeah.
Okay. The ownership of Ecstasy Bar and Restaurant, is it the
LLC,
LLC, is it the same ownership as new Ecstasy Bar and Restaurant?
you have to quantify what ownership. The license is held by, according to Rosedale, as the entity, as new Ecstasy Bar and Restaurant LLC. They could have the same people involved, but it's a new entity,
I
new
understand
W
that.
number, everything.
You don't understand what that is, but my question is, the operating agreement for the LLC, are the members, the managing members and the members, are they the same people that?
Some are.
Some are the same in both? And the case that you brought forth, can you explain that case on the record?
That case,
Do you have a copy
I'll
for
give
me?
you a site on it. I'll just have the first page. It's Rosedale Plaza Limited Partnership versus LEFTA. It's at 780 A Second 387. That says that the ownership of a liquor license is by the corporation or LLC, not individuals. Court of Special Appeals case, what's it now, Supreme Court now, I think, but it's,
Yeah. Is it Court of Appeals or
it says Court of Special Appeals.
Special Appeals?
It wasn't, hasn't been overturned or taken up on cert.
And your argument is that since the ownership is by an entity and not a person, explain that argument.
That is what the law is, that the entity itself, because licensees could be on a license and have no ownership interest in the LLC or corporation.
Correct.
But the law says that the entity itself or the LLC is the one that holds the liquor license. And in this case here, the judgment or the fine that was against Ecstasy was after the license was transferred to new Ecstasy, so it's a different entity. So it's improper for new Ecstasy to be here under that charge.
Okay. I may want to pull it before we make a decision on that. Okay.
And sir, you don't have to necessarily rule today. We can issue a ruling at a later date.
I do want to look into what you're saying, and I do want to read the case myself.
And to make it easier, which I don't often do, but I'm starting to like you all, the two
Like
exhibits.
us? Is that what you're saying?
The two exhibits that the state has will stipulate that those exhibits will be reviewed also by the board and against the Ecstasy, so they don't have to put that on the record, but it's up to them. And
Okay, so I want to reserve ruling on
The motion.
on the motion, which I will rule on that later. Let's conduct the full hearing, and then I want to look at the case before I make a ruling on this case in general. Okay,
I can give you just the front sheet, but
but you know I'm going to read the whole thing. No.
you get old, I guess you can't walk around.
All right, we'll pull it. Thank you. All right, let's proceed.
Good morning.
Swear in.
Yeah, you got to raise your right hand and say your name for the record, and you're going to swear you in.
Do you swear or affirm under the penalty of perjury that the answers that you give and the statements that you make will be the truth, the whole truth, and nothing but the truth?
Both of you.
I do.
I do.
And can you state and spell your name?
Erica, Erica, last name is Cook, Cook.
And ma'am.
Saron Taylor, Sirron, last name Taylor, Taylor.
Mr. Budinski, is your client going to testify or no?
No.
Okay. Go ahead, Ms. Cook.
Good morning. Erica Cook on behalf of the Uninsured Employers Fund. We are here today because Ecstasy Bar and Restaurant failed to have workers' compensation insurance, and as a result, their worker was found, their injury to their worker was found compensable, and thus it was determined that Ecstasy Bar and Grill did not have insurance, and as a result of that, they were assessed a fine of $20,000 as a result of that. And in addition to that, there were additional fines as a result of the injury to the worker that resulted additionally to that as well.
Can you explain as you go forward when the injury happened and what entity, just the exact name of the entity?
Yes,
it was?
the injury occurred on January 18th, 2019, and it was determined that the worker injured their right ankle, and it was also determined that Ecstasy Bar and Restaurant LLC was not insured at the time.
When was the hearing?
And that hearing was held on August 25th, 2020. And then there was another hearing to determine the permanent disability as to the injured worker, and that hearing was held on August 28th, 2024. And at that point, it was determined that the injured worker suffered a 30% loss of use of their right ankle at the rate of $372 payable weekly beginning October 3rd, 2020 for a period of 75 weeks. Now, we do understand that, and we are here today for new Ecstasy Bar and Restaurant LLC. Now, while we do understand it is technically a new entity, however, it's the same principles, it's the same location, the same trade name, everything.
Trade name's the same?
Yeah, the trade name, it's my trading as My Cousin's Place, LLC. Everything is exactly the same. The only thing that has changed is they added new to the name.
Thank you. Anything else?
No.
Any questions?
But there's no doubt that your final orders were against Ecstasy Bar and Lounge LLC.
He's asking you the question.
I'm sorry.
Yeah, there's no doubt that your orders are against the Ecstasy Bar and Lounge LLC.
No, yes, they are.
All right, and then along with that, have you seen if that LLC is active or not?
No, it was dissolved.
Okay. I have no further questions.
Okay.
The only thing I would add, and when you look this up, is it's not technically, it is actually. It has a new LLC, they have new registration numbers, no CR numbers, and the new workman's comp numbers. They couldn't have had the license transferred, they didn't give you workman's comp. Just want to add that when you look it over.
Okay. Thank you.
I'm sorry.
Go ahead.
I mean, and I would just like to add that the courts have held that a liquor license is a privilege, and the liquor board has the power to circumscribe that privilege is deemed necessary to prevent its abuse. Furthermore, the court noted that the acceptance of the privileges and benefits of a liquor license carries with it a burden that licensees are held to an exacting standard of conduct.
Yes. Thank you very much. We are going to reserve any other argument at this point.
No.
Any questions, commissioners, before?
No question, Mr. Chairman.
Do you have any questions for?
I have no questions, but I do want to put on the record that there is extensive violations. 2025, May 2025, February 2025, December 2020, going on down to 2016,
Yeah.
Chairman.
And I would just note for the record that that is against the new ecstasy, not the ecstasy, and your record indicates that the transfer was made in '23. Fine.
Is it, you mean ecstasy, not the new ecstasy?
No, it's to the new
The other
ecstasy.
ones are against new ecstasy, so the board recognized New Ecstasy LLC, not Ecstasy Bar and Restaurant LLC, just for the record. In case we don't know where we're going with this, so we're going to make sure the record's complete.
Yes,
Thank you.
That's perfect. So I think we've heard everything. Thank you guys for your time today. I'm going to reserve our ruling to later. And thank you. Appreciate it.
Thank you.
Nathaniel Branch III, Arthuretta Sanders, and Artira Watkins, Beulah Lounge LLC, trading as Beulah Lounge, 5707 Bel Air Road, Class B, beer, wine, and liquor license. Violation of Rule 3.081B, sanitation and safety on March 7, 2026. Patrons smoking hookah inside the establishment in violation of Maryland Code Health General, Section 24-504, also known as the Clean Indoor Air Act. Violation of Rule 3.12, General Welfare on March 7, 2026, loud music. Violation of Rule 3.092, Restroom Facilities and Health Regulations on March 7, 2026. Violation of Baltimore City Health Code, Section 9-312A. And finally, violation of Rule 4.171, storage on March 7, 2026, storing alcohol in an area that is not covered by the liquor license. Please proceed.
Thank you. And before we go forward, I mean, just for the attorneys, if there are motions, I would love for those motions for us to get those ahead of time. If there's case law, even if you bring the case law, we can read it here on the spot and make the rulings faster if we have those things. Yeah, that's all. But go ahead.
Good morning, Chairman, members of the board. For the record, Gary Maslin, on behalf of this applicant. He's one of the finest licensees I've ever represented in 50 years and very diligent and hardworking, amazing. That being said, denies the allegations.
You're not what?
Denies?
Denying the allegations.
You're denying the allegation. Okay, let's move forward with the hearing then. Thank you. Go ahead. Can you please swear in our,
Do we want to swear in all of the agents who may testify?
everyone that's going to testify today, please stand up and raise your right hand and speak audibly.
Jesus Christ.
Do you swear or affirm under the penalty of perjury that the answers that you give and the statements that you make will be the truth, the whole truth, and nothing but the truth?
I do.
That would have been a good picture.
Jesus Christ. It's like I'm at a wedding.
Go ahead.
Good morning, Agent Tuttle, Baltimore City Liquor Board. On 3/7/2026 at approximately 1:32 a.m., myself and Inspector Jordan and member of the Social Club Task Force responded to a 311 complaint for alleged disturbing the peace, loud music, and front door open. Complainant stated that the music and bass were extremely loud. Once we arrived, we are parked across the street, and according to Google Maps, we're approximately 190 feet away from the establishment and could hear loud music emanating from the establishment. The noise level was clearly excessive. Upon entering the establishment, we observed an extremely large crowd inside, approximately 60 patrons downstairs, and once we were able to make our way upstairs through the crowd, we saw approximately 60 patrons upstairs standing and smoking charcoal hookah. During my inspection, I found that the establishment was storing alcohol in the basement, which is outside the scope of their license. I made contact with the manager, Ms. Watkins. Ms. Watkins stated that that they were having a private party and it got out of control, but the establishment was closing for the night. I informed Ms. Watkins that she would be receiving violations Captain Dawson from the Fire Marshal's office notified the establishment that he was closing it for the night due to unsafe conditions. The task force left without further incident.
Any questions, council?
Now, she was very polite and cooperative with you.
She was.
And did you ever inspect this establishment in the past?
I have.
It's been there over like 30 years, isn't that correct?
I believe it's a new establishment, Pool Lounge, and it's only been open last year, if I'm
But
correctly.
The license has been there for over 30 years.
Yes.
And one of the things you cited for was not having alcohol stored properly. The alcohol's always been stored in the basement of that establishment for 30 years.
I can
Are you
only
aware
go
of
what's
that?
on this liquor license, and this
You
liquor
just
license
looked at what
stated.
was on the liquor license.
Yes.
And it's never been cited in the past 30 years for having
I can't
alcohol.
speak of the last 30
I
years.
understand that. I have any other questions for you?
No other questions?
No.
Okay. Any more testimony from,
No more testimony.
go ahead.
We move to have the violations dismissed. There's no testimony supporting the fire violations. There's no testimony supporting the health violations.
The health violation, you mean the hookah is not a health violation to you?
Well,
Is that what you're saying? What's your argument?
Hookah is a health violation. I'm talking about the fire violations. There's just a broad statement. There's no testimony presented to the board about any fire department violations. And as to the storage of alcohol, it was in the basement of the premises. Technically, it wasn't on the UNO permit, but it was on the premises. And it's been there, this establishment's been there 30 years. This isn't something newly created. So I'd submit that the evidence is deficient to sustain the violations. She's charged with
I want you-
sanitation and safety. That's the hookah violation.
Correct.
The general welfare is there's no testimony about any neighbors complaining that are here today. It's just they heard something out there, and the time she went there, it was 1:35 in the evening. The place closed about 15 minutes later. It was done for the night. So the timing as to how long it had been, the loud music had been going on is questionable, but it was clearly abated. The allegation about restroom facilities and health regulations, there's no testimony at all presented as to that. And as to storage, it was clearly on the premises, Judge, and we'd ask that she not be held accountable for that.
Okay, so what's your argument on that one, at least the storage? I'm
Well,
not
it was-
tracking because
it was-
your argument sounds like the prior licensees in the past stored everything that way. So your clients did the same thing.
They didn't change anything. It
They
was
didn't
all-
change anything.
No.
But if it was done wrong in the past, what I'm trying to,
It's never brought to their attention that there was anything wrong with how alcohol was being stored in the basement for 30 years. And now there's something.
it sounds like your client didn't look themselves to make sure that they were storing it the way that they're licensed.
Well, but I can tell you that issue's been addressed now since
It's
it was
been
brought to her attention. She applied to amend the UNO, she moved it out of the basement, all that was corrected.
Yeah, that's what I want to hear. That's perfect. But
Yeah, all that's been corrected.
I don't see any other violations in the past.
She
It seems
is
like
a- she is a,
they've been
um,
great
This is a
licensees.
tremendous asset to this community. We have letters from she's a member of the Community Association. I have letters from the Community Association attesting to her participation in their community, and that she is a valued asset. She attends all of the community meetings, and she even writes letters to the community herself, thanking the community. There's a petition she has in support of her. I have here today, and here's a letter from the, if I could offer this, from the Frankfurt Improvement Association. It's a
Yes.
rolling letter saying what a valued member she is to this community.
Since you're doing mitigation, can you tell me more about how hookah's being handled or not being handled now?
Now, here's the thing. They don't allow hookahs there. What happened here was it was a private party. These people came in. They brought in hookahs. They don't have hookahs there. She doesn't permit hookahs there. There's signs up that says no smoking there. It just slipped by her when they went in for this party. And as to the music part of it, she's very diligent about keeping speakers down. She has an outside speaker. She makes sure that those speakers are cut off at 9 o'clock so that there's no disturbance in the community. And she never had any complaints from the community, as you can see from the letter from the Community Association. Here's another petition supporting her, just local people. Sign a petition in her support, showing how much appreciated she is in that community. She runs a very strict operation there. She has security at all times. I have certificates from her, the employees that she has a security. I have a certificate that Ms. Watkins was there, the licensee was there. This is not a licensee that sheds her responsibilities. She has a certificate of achievement. She's completed a course in crowd management training, as well as hiring security. As a result of this unfortunate incident, the fire department closed her down for relatively minor incidents, minor violations, and it took the fire department 3 weeks to come back. So she was actually out of business for 3 weeks over very minor infractions that she corrected immediately. Immediately it was corrected. The stock was moved upstairs. There's an application for a UNO permit pending to get that back on track. And
Okay. Any questions, commissioners?
No questions, Mr. Chairman.
well, if I just briefly,
I do have a question. And I will pose it to the council, and if Ms. Watkins would like to answer, but is it true that you stated that you believe that the party had gotten out of control?
You got to raise your right hand or talk to your attorney.
Do you swear or affirm under the penalty of perjury that the answers that you give and the statements that you make will be the truth, the whole truth, and nothing but the truth?
Yes.
And you're Artiera Watkins?
Yes.
Okay,
I did not make that statement.
okay. You received payment from this party to be at your establishment?
No, ma'am.
So what type of private party was this?
It was actually our security team's senior anniversary. And so they had a party there.
Okay.
So it was still open to, customers as well.
So your security team is part of your staff or associated with your business?
No, we have a contract with them. We contract with them, so they don't work.
Can you talk in the mic a little
Oh,
bit?
I'm sorry.
'Cause it's all being recorded live.
Okay. No, the security staff doesn't work for Bula Lounge per se, but we contract with them to do our security.
Okay. So, but you are aware that you can't have any smoking in your establishment, and that includes hookah?
Was aware the night that they came in, and the next day when I received my renewal application with the flyer, and they're stating that no smoking of hookah indoor due to the Clean Clear Act. So prior to me getting my liquor license and submitting my application, I was not aware.
Okay. Do you believe that your restroom facilities were compliant,
Yes,
that they were clean?
yes.
You had toilet paper? Hand
My
soap,
knowledge, yes,
paper towels, or drying?
yes.
Okay. And the steps, have you made steps to make sure this doesn't happen again, even if you have a private event there, that they don't bring hookah, that your staff, if you're not there, that your security that you contract, make sure that doesn't happen in the future? That's what I'm concerned with.
Yes, and we also have our bar manager here as well, that when our absence, that I'm not there, she's there and running the bar, and she's fully aware of what's required and what's not. She has like over 10 years' experience working in the bar field.
And make
so-
sure they check on the noise also, because
Yes.
noise violations, you violate the liquor board rules when you violate other agency rules like the health department. And so there are two violations, like the restroom facilities and health regulations. You have to still comply with state and city health department laws, rules, and regulations. And when you do that, when that noise is too loud, that violates that, which then I can violate you. This board can violate you here. So just stay on top of that.
Understood.
All right. I have no other questions. We're ready to make a.
Your Honor, if I may?
Yeah, go ahead.
Yes, sir. Dave McGinnis, Chief Inspector, Baltimore City Liquor Board. Referring back to the cease and desist order on the screen issued by Captain Dawson of the Fire Marshal's Office. If we look, these are failure to maintain components of required egress, an unsafe condition if people cannot are able to escape. Failure to maintain hood suppression system. It's required around all cooking facilities, and use and improper storage of liquid fuel gas, LFG. Again, these are life safety issues that merited the closure, not minimal fire safety. And I'd also like to refer to on the screen was a screenshot from Bula Lounge's main Instagram advertising a 24/7 takeover. The bottom left corner, hookah, drinks, food. So again, we do have an advertisement from their direct advertising the hookah.
Thank you.
So thank you, sir.
All right. So we're ready to make a ruling on this. Based on the charging documents, the testimony that was given today, the proffer made by counsel, heard all of the arguments that were made on the three violations, the exhibits that we had prior to the hearing and the exhibits that were entered today. I do find there was a violation of Rule 3.081B, sanitation and safety. I do find that there's a violation of Rule 3.12, general welfare. I do find a violation of Rule 3.092, restroom facilities and health regulations, and I do find a violation of Rule 4.171, storage. I'm going to issue only a $250 fine for each of those, so that's a total of a $1,000 fine, because I think that you hear what we're saying about making sure that you have everything in order. I think that you hear what we're saying about not just looking at what's done in the past, making sure that you are in compliance with our office. Our office is very, very helpful, more than any other. I don't want to say the agency, but it is.
I'm sorry, you said helpful?
Helpful if you need help.
Okay.
If you need to know what the rules and regulations are, if you need us to tell you or show you what you need to do, what you can't do, we're going to help you every single time, okay? And I see that there were no violations in the past, so that's why my ruling is only $250 for each of those violations. Now, if you come back and do some of these same things, it's not going to be the same, okay?
Okay.
You understand?
Yep.
Yeah.
Mr. Chairman, just one thing. She did receive a citation from the health department. It's a $500 citation for the hookahs. I wonder if you could abate your 250 one, because she's still obligated to pay the $500 citation that she received independent of this.
Yeah, that's different than ours. So no, I appreciate that argument, but she's receiving a nominal fine and 30 days of pay, and we'll see what the other commissioners say, because obviously they have to agree.
I concur with the chairman. I think that we won't have this issue with the current owner anymore. And looking at the record, as the other commissioner said, that this establishment has been in good faith for the community, and I think that this is just a lesson learned. But based off of the ruling of violation 3.08, 1B, violation 3.12, general welfare, violation of 3.09, 2, restroom facilities and health regulations, and violation of Rule 4.17.1. I also concur with the chairman for a $250 fine for each one and 30 days to pay.
I do find that you have a violation of 3.081B, sanitation and safety, on March the 7th, 2026. I find a violation of 3.12, general welfare, on March the 7th, 2026. I do find a violation of 3.092, restroom facilities and health regulations, on March 7th, 2026. And I find a violation of Rule 4.171, storage, on March 7th, 2026. I'm posing a fine of $250 each, a total of $1,000. I do believe that you are concerned about being an upstanding licensee, and that you will be moving in the right direction. But clearly, based on the evidence that was submitted and the testimony given, you were in violation.
We see all the time when establishments have a hard time, sometimes they resort to the hookah, the private parties, the promoters, and that's when things start getting out of hand because you can't really control what's going on, or you have to be there and control it. So that's what I want you to just keep that in the back of your head. Okay?
Yeah.
Thank you. Thank you, Councilor.
Thanks, Tom.
I call exhibits for the record. Board Exhibit 1, violation report, Agent Todd Hope. 2, cease and desist. 3 through 4, photos. 5, letter of support from Frankfurt Improvement Association dated 5/21/26. 6, petition of support. 7, crowd management training certificate. 8, security guard certifications, and 9, security plan.
Thank you, Ms. Russell.
Keisha Jenkins and Sashi Thapa and Aperna 108 LLC, trading as Good Vibes Restaurant and Bar, 2903 O'Donnell Street, Class BD7 beer, wine, and liquor license, violation of Rule 4.011, sales to minors, on December 14, 2025, violation of Rule 3.033, records on December 14, 2025, for failing to provide employee records. Please come forward.
Abraham Hurd on behalf of the licensee.
How are we going to proceed today, Mr.
It's
Hurd?
going to be an admission. I do have a couple curveballs, but they shouldn't be too complicated, but we'll see if they work. We'll
Am
find
I
out.
going to need to read case law for your curveballs?
No, not at all.
Go ahead and explain what happened.
Agent Tuttle, Baltimore City Liquor Board. On December 13th, 2025, myself and Chief Inspector McGinnis, along with the members of the Baltimore Sheriff's Office Neighborhood Service Unit and underage cadets, completed investigations throughout the city of Baltimore. At approximately 11:54,
Can we hold on one second? Is this on the screen? Is that from the last case? Or
That is the last case, Your Honor.
Can we? Go ahead.
at approximately 11:54, undercover sheriff deputies and a cadet Carter, who was under the legal age of 21 at the time of the investigation, entered the establishment known as Good Vibes Restaurant Bar, located at 2903 O'Donnell Street. Cadet Carter ordered and was served and paid for 2 12-ounce bottles of Corona for a total of $18, using a previously marked bill from the bartender, later identified as Mr. Luis Torres Velasco. After purchasing and being furnished the alcohol, Cadet Carter and the undercover deputies exit the establishment, confirmed that they were served. Moments later, the rest of the team entered and made contact with the manager, Miss Mary Franklin, who stated the employee was training at that time. Ms. Torres Velasco Mr. Torres Velasco was informed that no criminal charges would be filed. However, the liquor board would be issuing a sales to minor charge. The rest of the team exit the establishment At that time, Chief Inspector McGinnis informed me that he had observed people smoking inside and would be issuing a violation for that as well.
Any questions or anything?
Was a violation issued on the smoking? Because I just didn't see it. My apologies.
No, it's not there.
Is it pending?
That was my mistake. So,
It's a curveball that worked out.
And this is Cadet Carter?
Yes, sir.
Okay. And you took the Corona, you gave the Corona back, right?
Yes, sir.
Okay, thank you.
$9 a bottle. I spoke to my clients about the issues. One of the reasons we postponed it was one of the licensees was unavailable last time, and we also wanted to try to get ahead of making some changes. My clients forwarded to me today a full list of alcohol awareness certificates. Anybody handling alcohol at the establishment, it's my understanding, has been retrained, and I have a list that I will forward to the board of all those certifications for the alcohol awareness. They also informed me that the records issue in terms of making sure things are kept on the premises and available has been abated in some capacity. They should be there at all times. I informed them that's something that doesn't happen all the time when the inspectors come by, but they need to be willing and able to turn those records over. I think sometimes the issue is somebody's just a bartender and they're not necessarily aware of the licensing rules regarding the records as opposed to a manager. And sometimes there's some confusion when things are busy. But they do have the records. They are on premises. They do have all the payroll information available whenever the inspectors would like to go back. In mitigation, I would indicate that this is a first violation for both of these offenses. Previously, it was a different citation code case. Previously, it was a 401-2, and this is a 401-1. That's my first curveball. And my second curveball is I observed a really interesting thing that happened in Frederick County a couple months ago where they offered probation for a fine. And here we would ask for probation on the records issue since it's been resolved. Ideally, the probation would be for 6 months, and if they get caught again, they would be fined both times. But if not, the fine would fall off. And it would fall off of the record as well. Again, they've abated that issue. The records are available, and I will be forwarding, I assume, to perhaps Ms. Russell and Ms. Wurzberger, the alcohol awareness certificates. So we would ask for a nominal fine. We did spend some time discussing the fact that the minor, while it's a different violation entirely, totally unrelated to the other one, that it is a concern that it happened about a year and a half ago and that it needs to be corrected going forward. And they're aware that that's something that they need to do better. O'Donnell Square is a tough area for that issue, but they're trying to do better. And while I would never promise that they're never going to have an issue again, they're certainly working hard to make sure that it doesn't happen again.
Okay. You said they're working hard to make sure it doesn't.
Underage service doesn't happen again.
What are they doing again?
They've trained everybody in alcohol awareness, and they're trying to get their security to do a better job of screening everybody before they enter the establishment. That doesn't necessarily negate the situation where sometimes people get past security, and then the bartenders feel as if security would have pre-screened them. So they're doing their best to have it be a 2-point check situation going forward, where security checks them before they enter, and the bartenders try to check every time as well.
I see that it is a different, it's very similar.
Very similar.
Okay, it's still 4.01, right? There's 1 and 2. It still deals with minors. Both of these deal with minors. So that's our concern, and as you can see from our docket today, that's a big concern. You already
Absolutely.
know. You know that is. And this is leaning toward this may be an issue over and over and over in the future. So we just want to, I think you know what to talk to your client about to make sure that this doesn't, or try not to happen again in the future. But any questions, Commissioners, before I make a roll?
No questions.
I don't have any questions.
Okay. I do appreciate your argument about what other jurisdictions do with the probation. That's not our, we've been doing here, but I will look into that and take that in consideration in the future, but not today. I do, based on the charging documents, the testimony that was given, the proffer that was made by counsel, very great arguments, and in the exhibits we already had, I do find a violation of Rule 4.011, sales of minor. It's a $350 fine on that one.
Is it sorry, $350 or
$350 fine, 30 days to pay on that one, and violation of Rule 3.033 records, $250 fine on that one with 30 days to pay. I feel like they're getting another get out of jail card, but it sounds like they are making the efforts they need to move forward and not do this again.
I concur with the chairman out on violation of Rule 4.011, sales to minor, on December the 14th, 2025, a fine of $350. A violation of Rule 3.03, point 3, records on December the 14th, 2025, and impose a fine of $250 with 30 days to pay.
I also find a violation of Rule 4.011, sales to minors, and a fine of $350. I find a violation of Rule 3.033, records, and impose a fine of $250, 30 days to pay.
Thank you, Commissioners.
I close the rest for the record. Board Exhibit 1, violation report, Agent Tudhope.
Thank you. Appreciate it.
Armital Singh Man and Makenjit Singh Man and Jaya Inc., trading as Mr. Joe's Bar and Cut Rate, 1 through 3 South Highland Ave, Class BD7 beer, wine, and liquor license. Violation of Rule 4.011, sales to minors, on October 18, 2025. Violation of Rule 4.204B, prohibited activities by license type, on October 18, 2025, for failing to open the tavern area for on-site consumption when the packaged good area was open and operating. Please come forward.
For the record, I'm Melvin J. Konecki, representing the licensees. We're doing an admission on this one.
Okay.
No curveballs.
No cases, no curveballs. Go ahead.
Inspector McCullough, Baltimore City Liquor Board. On October the 18th, 2025, Inspector McCullough, accompanied by Chief McGinnis, Agent Perez, and members of the Baltimore City Sheriff Department, including Cadet Carter, under the age of 21, conducted BD7 checks and underage alcohol sales investigation throughout Baltimore City. Cadet Carter, along with 2 undercover sheriff's deputies, entered the establishment and purchased a bottle of Crown Royal for the amount of $21.79 using a pre-marked $20 bill and a $5 marked bill. Upon notification of the buy, we all entered the location and informed the store personnel that an alcoholic beverage has been sold to an underage sheriff cadet. We spoke to the individual identified as the store manager, Kuldip Singh, sorry if I mispronounced it. Mr. Singh informed me that the tavern portion of the establishment was not operational at the time. I advised Mr. Singh that accordance with the BD7 license requirements, the tavern must be fully operational whenever the bar area is operating. I advised the violation would be written for the tavern not operating and selling alcohols to a minor, and we left without further incident.
No question.
Just,
Go ahead.
did you ever make it into the tavern portion at all? It's not, it's separate from the packaged goods, isn't it?
We can walk back there from behind his counter.
From behind the counter?
Yes.
They have a separate door on the corner.
Yes.
But you never went in the tavern at all that night?
I did.
And was anybody in there?
No.
Was anybody in there cleaning up?
It was a cleaning guy in the bathroom hiding.
He was hiding.
Yeah.
He's probably getting his Crown Royal.
Crown Royal Apple.
Apple, that's when I've seen, finally they're stepping up. Stepping up. I'm not focused.
Go ahead.
Well, basically in this case here is this location is on the corner of Baltimore and Highland. I've known it for years. When Mr. Joe Stecca owned it. And it's a bad area, and they have to be very careful in there. They had it, from talking to the licensee, they had an incident in the tavern in which there were some tables and chairs were turned over, and they closed while they were going to be cleaning up. They understand that's no excuse that they have to be open. If they were going to close the tavern, they should have closed the packaged goods store. But they did not. As to the serving of the minor, the individual there was not acquainted, and the other owners were in the back. And what they've done is they've made sure everybody would be carded, even if I walk in and card every single person that comes in. And also that the bar portion absolutely has to be open the same time that the packaged goods is open. you can have the bar open but no packaged goods, but not vice versa. And sometimes it's hard for people to understand that when times are tough and they figure we'll close the bar and keep the other part open for a little while and try to make a little more. The past record haven't had anything for the last couple of years. It's an excuse, just pointing it out to you. Have everybody certified, and I don't think you're going to see that kind of situation here again.
Okay, let's talk about the elephant in the room. This is what, the 6 sales to minors?
It's been a while. I'm not just giving an excuse, but it's all in mitigation. For a while there, it seemed like and then at 21, 22, they had a bunch of them, and then now it's been like 2 years, and this happened. There's, other than being more vigilant, which we always say. I've been doing this 50-something years. It's going to happen all the time, and the people pay for it when it happens if they don't tell their employees. So I always take notice that employees don't take the same accountability that a licensee would have, and they're there just to try move things through. But in this case,
Excuse me, counsel, what I would say that training then is needed, right? Training.
yeah, but if training is
Your staff.
if they do it.
No.
Yeah, I got what you're saying, and I don't disagree. I'm
It's preventive.
I'm a trained lawyer, but sometimes I stumble also. Not often.
I was about to say when I saw you stumble, but that's No, I hear your argument. Any other questions, commissioners?
No questions.
You know what our concern is. It's the 6th one, the 6 sales of minor. And Commissioner is absolutely correct that training is an issue, instructing is an issue. And in your own words, the licensee pays for it when, I guess, their staff mess up. And that's what it's going to happen today. Based on the charging documents, the testimony that was given today, the proffer that was made by counsel, I do find there was a violation of Rule 4.011, sales of minors. Based on it being the 6th violation, $2,500 fine on that one, and 30 days of pay, and a violation of Rule 4.204B, prohibited activities by license type. This is the first violation on that one, $750 for that violation, and 30 days to pay on that one. And if it keeps happening, the fines will keep going up until they're either suspended or revoked. So,
Just for the record, Mr. Chairman, what was the,
$2,500 for the first violation and $750 for the second violation was my ruling.
I concur with the chairman on his violations for 4.011 sales to minor, $250, $2,500 for violation Rule 4.04B, prohibiting access by license type, $750. I know we've been talking about training, but intervention needs to happen on with this licensee. Having 6 cases of serving alcohol to minors, it just seems a little excessive. I think we're past training. We need intervention on this particular case. So hopefully with these particular fines that things will change. Thank you.
I also find a violation of Rule 4.011, sales to minors, on October the 18th, 2025, pose a fine of $2,500. I also find a violation of Rule 4.204B, prohibited activities by license type, on August 18th, 2025, and impose a fine of $750, 30 days to pay.
Ms. Russell.
Can I call exhibits for the record? Board Exhibit 1, violation report, Inspector McCullough, and 2, photo.
All right.
Lourdes, Cancel, and Gervais Contreras, Union Centro Americana LLC, trading as La Isla Taverna, 3230 East Fairmount Ave, Class BD7 beer, wine, and liquor license, violation of Rule 4.011, sales to minors, on January 5th, 2026. Please come forward.
Good morning once again, members of the board.
Made admission.
This will be an admission.
Okay. You go ahead.
Good morning.
No purples. No memos.
Good morning, Inspector Jordan. On January 5th, we were conducting underage investigations with the Sheriff's Department. We went into the location at approximately 7:15 p.m., La Isla Taberna. Cadet Orellana, he sat at the bar and he ordered a Modelo beer. And he was furnished that beer. And then once that beer was sold to him, we went in and issued the violation. And at that time, we spoke to Ana Marcela Otero, and we let her know that they would be getting a violation.
Any questions or anything?
No questions.
Go ahead.
Please, this is a situation where this license is in the process of being transferred. It was before the board. It was approved for transfer. We're trying to get it completed. However, there were problems with the UNO division and getting permits done in time, and the time lapsed, and we had to reapply. There's another application now pending before the board for the transfer of the license to the same party. Right here, it's going to be the operator of the business. The individual who was there was she had alcohol awareness training, and she was terminated. She is no longer there. In the process of trying to get the license transferred, the inspectors came out and they found certain things that needed to be done, and they shut down the establishment right now. It's been closed now for almost 3 weeks. Yes. 3 weeks, and they're trying to work through the UNO process and the building inspectors, and hopefully that can be completed and they'll be able to reopen, and then we'll be back here before you for a hearing again to get approval to transfer the license to the same person you approved to transfer it once before. They're very sorry for what happened. Everybody who works there is alcohol awareness trained.
Okay. I'm looking back at the record now. See, 1, 2, 3, 4 other violations. But I am, okay. Some of these are a long time ago. 2016, that's what, 10 years ago, 2014. So the record is not as bad recently as I thought when I first looked at it. All right, any questions, commissioners?
No questions.
No questions.
Okay. Based on the charge documents, testimony that was given today, proffer made by counsel, and any evidence in the record, I do find a violation of Rule 4, and it was an admission done on the record today. I do find a violation of Rule 4.011, sales to minors. You said they're in the midst of a transfer, and they've been closed for 3 weeks.
It's currently closed. There's a lot of work that has to be done to the establishment, satisfy the building inspector, and that's in the process of being completed.
Okay, even with the record, my ruling is $750 or 30 days of pay. Nothing higher than that, yeah.
I do find a violation of Rule 4.011, sales to minor on January the 5th, 2026, and I pose a fine of $750 with 30 days to pay.
I also concur, a violation of Rule 4.011, sales to minors, on January 5th, 2026, and pose a fine of $750 with 30 days to pay.
Ms. Russell.
Thank you, Mr. Chairman.
Exhibits for the
Members of the
record.
board.
Board Exhibit
guys.
number 1,
Thanks.
violation report, Inspector Jordan.
Terrence Dixon, New Terra Cafe LLC, trading as New Terra Cafe, 101 East 25th Street, Class B, beer, wine, and liquor license. Violation of Rule 3.034, records on August 1, 2025, for failing to provide a valid trader's license. Violation of Rule 4.14, live entertainment without authorization, on March 17, 2026, for engaging in live entertainment after the hours that were approved by BMZA. Violation of Rule 3.12, general welfare, on March 17, 2026, for loud music. Violation of Rule 3.092, on March 17, 2026, for violation of Baltimore City Health Code, Section 9-3062, 1i. And finally, violation of Rule 3.02a, cooperation, on March 17, 2026, for failing to produce a use and occupancy permit when requested by Liquor Board staff. Please come forward.
Good morning. Can you please raise your right hand and testify?
Do you swear or affirm under the penalty of perjury that the answers that you give and the statements that you make will be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Yes. So you have 1, 2, 3, 4, 5 violations that you're here for today. You can proceed in one of two manners. You can make an admission, and they'll read into the record what happened, and then you can still argue and say what should happen, and say, yes, I did violate, but I want you to take these things into consideration, and I want you to minimize the fines, or I don't want you to suspend me or revoke me. Or you can ask for a contested hearing. That's the second thing you can do today.
I didn't hear the last part you just saying. I apologize for my hearing.
Okay, I'll start again. So there are two things that you can do right now, and it's your decision on what you do. You can say, I do admit to these 5 violations, or I admit to 1 or 2 of them, whatever you want to, and we can go through them if you want. And they're going to read what happened from their perspective, and then you can then state on the record, no, it didn't happen that way, or yes, it did happen, I did violate, but I want you to give me a small fine, or I don't want you to suspend me, I don't want you to revoke me. You can argue that after the fact. It's called mitigation, okay? Or you can say, I want to challenge the whole thing, or I want to challenge 1 or 2 of the violations. I want to do a full hearing, and I want to say that I wasn't in violation. I want you to prove your case. So do you want to admit that, yes, I was wrong, but I want to just explain what happened and ask us to?
I'd like to explain what happened.
Okay, so this is going to be an admission on the, okay.
And Mr. Chairman, I'm sorry to interrupt. If we can get
State your name, yeah,
Can you state your name?
My name is Terrence Dixon.
okay. All right, thank you. So I'm going to let them go ahead and tell us what happened, and then it's going to be your turn, and you can also ask questions if you want, okay?
Yes, sir.
All right, go ahead.
Agent Perez, Baltimore City Liquor Board, who testified on the August 1st, 2025 violation. The Social Club Task Force, at approximately 10:20 p.m., responded to the location in order to investigate a health department complaint in regards to rodent and insect infestation. At the time of our arrival, I began to conduct a routine inspection. Everything was in compliance except for the 2025 trader's license could not be produced at the time. I informed Mr. Dixon that he will receive a violation for failing to provide a trader's license as long as he had received a prior warning for the same issue. On August 14, 2025, I was able to confirm that no trader's license for 2025 had been issued to the establishment. Additionally, it was noted that on June 20th, 2025, Mr. Dixon has been instructed. It was noted that the establishment didn't have a license then, and he was instructed to do so within 30 days of that inspection, which it was never received. Nothing further to report.
Any questions on this violation?
Can I speak on that?
Yes, you can, but
All
do
right.
you have any questions for him or anything? No questions for our inspector? You don't have to. You can just,
I don't have any.
okay,
I would like to just speak on it, and then if you can help me through.
okay,
All
go
right.
ahead.
I don't have an attorney. I'm going to be my own and speak for myself. This has been not the first time, but the second, possibly the third. I've shared with the liquor board that I had to file a bankruptcy, like so many other businesses in Baltimore City that was promised and was not fulfilled after COVID. So we struggled with that. I shared you legal documents that I had in bankruptcy and, getting it together, all right? With the amount of businesses closed, I thought that we'd be respectful and say, hey, I'm not bad. At that point in that night, it was around 10:30, I went upstairs. We had a little comedy event, okay? Understand, my restaurant, we don't have hookah. We don't have twerking on the tables. It's for the mamas and the papas. Most of my clients or most of my customers, they got walkers. So 10:30 at night, my GM, Al, called me because I just went upstairs, and he says, hey, the liquor board is here. I'm like, okay. And he says...
This is on August 1st.
He says, listen, relax. I'll take care of it.
This is on August 1st, is that?
This is the August 1st one, okay? At that point, he calls me back with urgency in his voice. He says, we're being raided. We're being raided. And it turned out it was the mayor's task force. The mayor's task force came in. I said, listen, I'm going to come down. They came in. It was about maybe 7, 8, 9 folks with bulletproof vests on, which is very intimidating when you come into business, and especially a business like mine. It draws a line of where there's really something, an urgency and something wrong. As I said, I looked outside. My streets are quiet. No noise, anything of that nature. It was zoning. It was the fire department. It was the health department. And it was the liquor board. All right? And I know these folks. Zoning said, listen, we don't have any problem with your Chef T. Fire department, we don't have any problems with your Chef T. The health department stated that it was time for my annual inspection at 10:30 on a Friday night. They said that they had tried to reach me. All right, being in compliance, my hours are listed on my door, never a note or anything of that nature. Okay? With the liquor board, we've had this conversation before in reference to me having a bankruptcy and sharing documents and asking, listen, we're trying to get that weight back from COVID. All right? Health department at that point, how long was that, Baba L? An hour and a half, or it was a good while. They did an inspection at 10:30 on a Friday night. Okay? Liquor board already has known that we were in the process of bankruptcy and getting our stuff together. They proceeded to take a look and write it up. Okay? No problem. And that was basically that night. All right? Shortly after that, we were closed. All right? Due to the BG&E from COVID that was never taken care of. All right? And I didn't have the wherewithal to do it. Okay? They turned our power off. Okay? And so we weren't after that. So that's why. That's
So what
where we're
happened
at.
with the trader's license? I just want to hear from the trader's license.
It was all because of this. You can't get the trade license unless you do your taxes and some other stuff of that nature. And we still had, issues from COVID that we were trying to work out with. And right now we're in conversation with the controller's office in reference to trying to get this thing right.
Okay. So you're still working on that right now, though.
I have my accountant is working on it. They've given us a detail of what they needed. It's only a, piece here, piece there.
When do you think that you'll have that rectified?
Well, what we're trying to do is this. We're trying to actually get that paperwork to him by the middle of next week. But they shared that once we actually put it all in, what the next step for us that they'll be able to work with us with is that there's another form. I don't know the name of the form, 502 or 402 or something, that they will be able to make payment arrangements with us.
Okay.
All right, in reference to getting us back in good grace.
Do you know what you need to be in compliance with the liquor board? Have you gotten all the guidance you need from our office?
I didn't hear you. I apologize.
Have you gotten all the guidance you need from our office so that you'll be
I spoke to them
compliant?
and they told me what was wrong and what needed to be done. So I think I need to. It's maybe 3 or 4 quarters that I have to actually submit to them.
Okay, but you do know what you need to do. We have
Yes, sir.
told you what
Yes,
to
sir.
do. Okay, I
Yes,
just
sir.
want to make sure
I know
that
what
you
I
know.
need to do
from-
in reference to the state, and the state is the one that put the brakes on the liquor license. Until I get that done, I can't renew it.
Okay.
So, and I mean, they're very, very receptive. They say we overstand, and they've already said that they will work out the payment plan without any money
This
down
happens with a
because
lot of
we're not even
licensees.
open now.
They fix those issues, they come back to us, and this happens to a lot of licensees. They fix their issues, they come back to us, and we make sure that we issue their license, and then they're not in violation. And our concern, and my concern, is to make sure that we're not doing this dance over and over again over small technical
I
issues.
tell you what.
Okay? But I want to go through the other two.
Yes.
The other date, the March 17th date, and then you'll have more time to talk, okay?
Yes, sir.
Can we go to the March 17th date?
Yes, sir. David McGinnis, Chief Inspector, Liquor Board. On Tuesday, March 17th, 2026, which was St. Patrick's Day, at approximately 9:50 p.m., myself and Inspector Nazir responded to the location due to a 311 complaint. That's 26-00256-707 for noise. Upon arrival to the scene, I parked at the corner of 25th Street and St. Paul, approximately 105 feet away from the location. Upon exiting my vehicle, I could hear music at an elevated volume emanating from the establishment. As I approached the rear passageway, I observed a sign in the front that said Feel Good Tuesdays with karaoke and open mic scheduled from 7 p.m. to 11 p.m. Upon entering, I observed a live band performing in a semi-enclosed outdoor space. Per BMZA 2011-207, which was incorporated into the licensee's liquor license, live entertainment may not be conducted after 9 p.m. Sunday through Thursday. And live entertainment must be conducted indoors. Made contact with Mr. Dixon and introduced myself. I advised Mr. Dixon he was prohibited from having live entertainment after 9 p.m. on a Tuesday. Mr. Dixon stated that Council President Cohen gave him permission to have live entertainment outside the time frame permitted on his liquor license.
Any questions? Do you have any questions? Yeah.
No,
Okay.
he's reading straight from what happened.
All right. So in this one, you have 4 violations: the live entertainment, the noise violation, which would be the general welfare. Same thing with the next violation, dealing with the noise and cooperation. Go ahead and tell us what happened on that night and why did you do live entertainment outside the confines of when you could do it?
That was one of the first nights that we had actually opened back up in reference to trying to raise money to open up. All right. I had spoke to, I'm going to read, if I could trouble you to read a couple of texts here. But also one of the things is that every time the liquor board comes, they come with the onus of 311. When they come, I bought a decibel meter. Okay. All right. We're very cautious of the volume. Try to share with them, and they're not receptive to it. The same statement is that I do this all the time and I can hear. We're human. I think I can hear. Sometime I can't. That's why I asked you to speak back up twice.
Why after 9 p.m. though? Tell me that. Why after 9 p.m.?
Our Feel Good Tuesdays is normally we do it inside, but I actually come in and I have texts from him, all right, in reference to that I needed some help.
Yeah, you don't have to read those texts because he doesn't have the right to do that. So you have to. I just want to make sure that you follow what the
Yes, sir.
rules
Yes, sir.
are, and it seems like you were in violation. Do you understand what you can and can't do now?
Yes, sir.
Okay. And do you think this is going to be an issue again in the future? Because I see this is your, what, 1, 2, 3rd time with the live entertainment? No, 4th. This is your 4th, I believe, with the live entertainment. And this is your 4th time with live entertainment.
That is the one thing that the 311 calls, even when we're inside, that people, they say 311 calls, but one thing I've never seen in that protocol is that normally when you call 311, who's dispatched first is the police department, right? And of maybe 20 times or more over the year, 20 times of the liquor board coming and saying that they had a 311 call, we've never seen the police department at all. And that is protocol. If I picked up the phone and I say I have loud noise or something of that nature, they dispatch, right? Spoke to Z. Coleman. I shared with him that the only thing that I had is our entertainment. That's what we're known for over 18 years of community and culture, and not loud, not crazy, but just really jazz, gospel, maybe a little comedy, and that's basically it. And I asked him, I shared with him that I would like a letter from the council president stating that, listen, for right now, allow this business to get back open. Allow this community to get back full again. All right. He shared that he would. I have texts in reference to conversation with him and his assistant Tasha that it should be no problem, that I was okay. All right. That it was illegal and they would present me with a letter. Now, when he came, I shared with him that I spoke to C. Coleman. I said, this is our first time, brother. This is our first time. We were closed from September until then. And at that point, he said, okay, and then he left. But then he reached back and said that Zeke Cohen said no. But I have texts here. I have his office. lead here that's saying that they're working with legal, that it shouldn't be any problem at all. The letter is almost finished and ready to come to me. And I know it's two separate departments.
There
Mr.
are.
Council President, and he's
And,
here.
and clearly, he's probably trying to help. And he's trying to probably help in the way that he can. But we need to just stay within the lines. Was Mr. Dixon cooperative on the issues?
To an extent, do feel that he has been previously confrontational with staff to the point that they feel disrespected and they are getting blasted on social media for doing their jobs. And that is incorrect. That should not happen. They are following the rules set forth by the board. And I did speak to Latasha Gresham James from Council President Cohen's office the following day, as well as Christina Cortez from Councilman Jones' office, which is district it's in. Both offices did confirm that Mr. Dixon reached out, but he was advised to follow the requirements of his liquor license and no special permissions were conveyed or implied.
Let's talk about when they do come in. I understand, and we've had internal conversations, about this, and we know that it can feel a certain way when the social task force comes into an establishment, and if it's a large number of people with bulletproof vests and you have patrons in there, I understand it could feel a certain way. But they are doing a job, and we've instructed them to do it in a way that's respectful
Yes, sir.
to the establishment. That's very important to us. That's respectful to the licensee. It's respectful to the patrons that are in there at the time, but they do have to do their job. So the report that the social media is going on, that sometimes you may not be as respectful when they come in. Do you have anything to say about that portion of it, or?
What I ask all the time as before, I share that when they come in and they say it's too loud or something, I went out and bought a decibel meter, all right? When I first opened up with the live entertainment, the state came down and they showed me basically 3 points of where to take the decibel meter and go out and do a sound check and make sure that it's palatable. It's not too loud. And I do that, all right? When they come in, I ask them, they say, well, we heard it. I've had reports of where,
I mean, your interaction, though, with our staff. That's what I'm discussing.
disrespectful. I never call them out their name.
Okay.
All right.
Just want to make
I offer
sure.
them the opportunity to listen to the decibel meter. Okay. And to really, as I said, we're not hookah dancing on the table. These are old people.
Yeah, this establishment has never been that.
Yes, sir.
But I just want to make sure, because we're always respectful. You're respectful when you come in here every time. You are every time with us. But you can disagree all you want. You don't have to, especially when they come in there. You can be upset, but we just have to make sure that we all remain respectful
sir.
to each other.
Yes, sir.
And there's always a time to argue or fight it, and this is the time to argue and fight
Yes,
it.
sir.
Not on the scene, not on the day. I just want
Yes,
to make
sir.
sure that.
The one thing is that when they came that time, I felt as though that I was being weaponized at that point, because for me to have the health department, all right, and for that to be the introduction of the reason that you have 8 to 9 city officers in my establishment at 10:30 on a Friday night, okay, it just felt
Felt that way. But you're not the only one. When there are 311 calls, there are a lot of other establishments that are having the same thing happen to them also, okay?
Yes,
So
sir.
you're not singled out in that fact. But
Yes, sir.
let's make sure I think you're moving in the right direction, but we're ready to roll. Any questions, commissioners?
I have one question, Mr. Chairman. Are you currently open?
I'm still struggling to get there, brother.
So I commend you for coming. I commend you for coming to this hearing, even though you're not open, and you've been in a very important establishment in that community. And I hope you'll be able to work this out.
I apologize. My hearing is going worse than I think it is.
Okay.
He commends you for coming today,
Thank you.
considering that you're closed.
Thank you.
And you're a very important
Thank you.
establishment in the community.
Thank you.
And he hopes to see you open again.
My hearing aid.
Any questions, Commissioner?
Mr.
I'm looking
Dixon,
forward to it, and so thank you for that.
Mr. Dixon, I do understand that you have been a mainstay in that corridor on 25th Street in St. Paul for a number of years.
28 years.
28 years. But you do remember signing an agreement
Yes, ma'am, and that's another discussion.
that's
That
really
is-
important. It's a binding document that states that there are things that you cannot do.
Yes, ma'am. That MOU that I signed with the Charles Village Civic Association, it was an MOU that was signed when I was on the Charles Village Benefit District Board. It stated that when I actually applied for the outdoor entertainment, all right, and at that point, I'm on the board. I'm thinking these guys are rocking with me, and this is the standard protocol. They told me that I had to sign it. At that point, I signed it. They said for 5 years, okay, that I could not apply for a liquor license.
But what I'm
And me-
speaking of is the municipal zoning board, the B.
It's with the zoning board.
Yes.
And if I could just continue, please. For 5 years, I had to actually do that. And I know that normally in business, that if you have a contract and it's for 5 years, guess what happens after 5 years and 1 day? You can't save pieces of that, all right? The whole thing is gone.
This isn't for 5 years, sir. This isn't for 5 years. This isn't for 5 years. There's no,
Ms. Commissioner, the original MOU was for 5 years because it was 5 years that I could not apply for a liquor license, and that was part of the MOU, that they granted me the ability to do live entertainment, but I could not apply for a liquor license for 5 years. At the end of that 5 years, understanding was that the MOU dies because it's the MOU for 5 years. And what has happened, and just recently, this last year, is that it was never on my liquor license before. Never. All right? And what happened this last year, or the year before, all right? A little shaky with time, all right? But it was actually put on my liquor license. And I didn't think that that was fair because the MOU was only for 5 years. If I write a contract with somebody and it's for a certain period of time, I would think that that's it. I didn't think that you had the ability to cherry pick those things off of it that you want to proceed and keep on it. That's my understanding. And even when I went to zoning, we did an amendment to the existing, and that wasn't a good situation either because they didn't even show up. We had 2,107 signatures. We had about 60 people in that court. We were second on the document, and they pulled the filibuster of where, at that point, we were put
Filibuster?
last. They didn't call us until 4:30, which most of my support left at that point. And it's just been an ongoing conversation in reference to how do we get to this part? Because when I go to zoning, if I go to zoning counter, they tell me that I have live entertainment from the front door to the back door, that you can't dissect it like that. And I'm stuck in that conundrum of what do I do and where do I do? And I do understand, Commissioner.
okay.
So we're ready to make a
I
ruling.
just wanted to share that. And I actually,
Thank you for your testimony. I appreciate
All right.
it. Thank you. Based on the charging documents, the testimony that was given today, the statements that were given on the record, and the exhibits that we already have in this case, I do find a violation of Rule 3.034 records on August 1st, 2025, the trader's license issue. You said you're working on that, $500 fine.
wow,
There are
I'm not
fines.
open right now, man.
I know, but there are fines that are going to be
And
issued.
it's like the third time I've been written up for the same thing.
I hear you.
If you could truly show me some leniency, because at this point, then you're going to close my business forever.
Okay. It's not going to be closed forever, but there are fines that I am recommending in this case, not as high as, let me finish my ruling. I do find a violation of Rule 4.14, live entertainment without authorization. These other violations are on March 17th, 2026. I do find that this has happened, this is the
It's the fourth time.
fourth time. There's a $1,000 fine for the live entertainment, Rule 4.14. Violation of Rule 3.12, general welfare, $250 fine for that one. Violation of Rule 3.092, restroom facilities and health regulations, $250 fine for that one. And then the last violation is Rule 3.02A cooperation, a $250 fine on that one. So those are nominal fines on those last three. Those last three were $250 fines on each of those. 30 days to pay on all of those violations.
I'm not
Commissioner?
even open.
So you're saying you can't pay the violations within 30 days? Do you want me to tell you what the total amount is?
Excuse me?
Do you want me to tell you what the total amount is?
Please, thank
Okay.
you.
1,500 to 2,250. $2,250. Can you pay that within 30 days, or do you need a little bit more time to pay it?
I can't pay it. I'm not even open. Trying to figure out, getting
Do you need
back
60 days to pay do you need 60 days instead of the 30 days that we normally get?
I would trouble you to, if I can get 120 days, because I'm still trying to figure out how to navigate to get back open right now. I don't even have the funds to actually pay for the liquor license. So I plan to be operating with just selling food. And at this point, it's going to be a slow roll, right? I don't want to say something that I can't do it, give me 30 or 60 days when I know that I can't. All right? So I would ask you to be lenient with me. I would ask you to be even a little bit more lenient with the fines. Okay? If you can.
Okay. And this is me being lenient with the fines, and I understand your predicament right now. So when do you think that you'll be ready to open again? How long do you think it's going to take?
I'm trying to actually do something with Grub, with the delivery service in the next week or two. Okay? You know already, they take 30% of whatever you make. So it's going to be a slow roll. Okay?
Okay, 75 days.
Hmm?
I'll say 75 days to pay.
75 days?
Yeah.
Thank you.
Okay.
I got a question for you.
They have to
If
make
I'm
that
not,
ruling.
if I'm not able to pay them in 75 days, can I ask you for an extension? Or is it something I can pay partial on to show good faith as I'm going along?
He can come to us and ask if he needs a little more time. Yeah. You can contact the office if that's the case. You can contact the office if that's the case, okay?
Yes, sir.
All right. Go ahead.
I concur with the chairman on violation of Rule 3.034, records on August the 1st, 2025, $500 fine, violation of Rule 4.14, live entertainment without authorization, $1,000 fine, violation of Rule 3.12, general welfare, $250, violation of Rule 3.092, restroom facility and health regulations, $250 fine, violation of cooperation on March the 17th, a $250 fine with 75 days to pay.
I do find a violation of 3.034 on records on August the 1st, 2025. Impose a fine of $500 for not having a trader's license. I find a violation of Rule 4.14, live entertainment without authorization on March 17th, 2026, and impose a fine of $1,000. I do find a violation of Rule 3.12, general welfare, on March 17th, 2026, impose a fine of $250. I find a violation of Rule 3.092, restroom facilities and health regulations, on March 17th, 2026, impose a fine of $250. And I find a violation of 3.02, cooperation, on March 17th, 2026, and impose a fine of $250 with a total of $2,250 with 75 days to pay. Mr. Dixon, I would say that sometimes as a business person, we have to think about how we're going to be able to do business, for sure. If it is still in your heart and it's in your passion to be a restaurateur, you're going to find the way. You will find the way.
You guys have made the fence
But
very
we-
high to get over.
No, but there are rules and regulations,
Yes, ma'am.
and we cannot just step aside when you have violated them.
Yes, yes, ma'am.
I'm wishing you every good thing. I'm wishing you good luck.
Yes, ma'am. Thank you.
You can do it.
Yes, ma'am.
Ms. Russell?
Article exhibits for the record. Board Exhibit 1, violation report, Agent Perez. 2, violation report, Chief Inspector McGinnis. 3 through 6, photos, and 7, zoning appeal.
Thank you. Appreciate you.
Thank you.
Jeffrey Danick, Holy Free Holies, Inc., trading as Holy Free Holies, 908 through 12 West 36th Street, Class B beer, wine, and liquor license. Violation of Rule 4.011, sales to minors on February 11, 2026. Please come forward.
Good afternoon.
Yes, good afternoon. Stephen W. Fogelman on behalf of the licensee, Mr. Danick, standing to my left. It's going to be not responsible
Okay.
because lawyers don't do guilty with explanation.
Is your client going to testify or no?
No.
Okay. Go ahead.
Okay, good afternoon. On February 11th, myself, Chief McGinnis, Agent Todd Hope, and members of the Sheriff's Department were conducting underage alcohol sales investigations. We went to the location at approximately 9:45, the location being Holy for Holies on 908 36th Street. The cadet went into the bar and ordered 1 bottle of Corona, Cadet Lily, beer, priced at $6. The cadet was provided and served the beer and paid for it with a $20 bill. After the beer was furnished, we went inside, spoke to the bartender and seller Logan Dorix, along with other staff there at the restaurant, and informed them that a violation would be issued.
Any questions?
Yes. Could you tell me again who was the deputy?
I believe we work all night, so there's a lot of members here involved. I believe it was Cadet Lily. Is that correct?
Are you Cadet Lily, sir? Yes, sir. Okay. And I've seen you in the video, but I don't recognize the deputy.
Oh, I didn't say any deputy. I said Cadet Lily.
Right, but the report says that a BCSO deputy along with a cadet. And quite frankly, in every other 4011 case today, in all the violation reports, it identifies both the cadet and the deputy by name, except in this case. Why is that?
The members of the Sheriff's Department could inform you exactly who went in. I didn't go in with them, but sometimes they go accompanied with a officer, sometimes they go alone, and I can't remember in every instant, like, who goes in.
Let me ask you about that. You say sometimes they go in with a deputy and sometimes they go in alone. Is that a change in policy? Isn't it in the past that the cadet would go in and then the deputies would come in after the sale?
I think somebody from the Sheriff's Department would be better to answer that.
No, I'm asking you based on what you know. You're an agent.
I don't make those decisions.
If you know.
I don't make those decisions at all.
But all I'm asking is, have you noticed a change?
I've seen it both ways.
All right, you say you've seen it both ways even in the past?
From as long as I've worked here, yes.
Okay. All right, and so you don't know the placement, the proximity, the closeness of the deputy and the cadet at the time of the sale, do you?
No, I don't.
Okay. All right. At this time, and I made this point, look at all the other violation reports that you see before you today. You've got quite a few for 4011s. This one doesn't even name the deputy, doesn't name the cadet. You're an excellent defense attorney in your other job, and this is akin to a violation of the Confrontation Clause of the Sixth Amendment to the United States Constitution. Furthermore, and I've submitted a photo from the video But you've got a deputy who we don't know who it is, and a cadet who we now know who it is. We're very close together. And it can be confusing for a server, quite frankly, know who they're serving. And I've been, affiliated with liquor board work for almost 20 years. And it's been standard practice that the cadet goes in, the cadet makes the sale with the marked bill, and then the deputies come in. But when you've got somebody who looks 40 next to a guy who maybe looks 23, that can be confusing. I'm not saying it's deceptive, but it's a little bit slick, especially in a crowded bar situation. And I have forwarded a still of video from the proprietor to demonstrate that. I just got retained, so it's been sent to BLC evidence at gmail.com, just so you have it for the record. And it's tough because it's not as cut and dry as many of these cases in the past that you've dealt with suggest.
I hear your argument. I don't know if they've finished their case in chief, though.
All right, well, we've got a single charge, so.
I didn't know if there were anyone else that were going to testify, that's all. Is there anyone else that was going to testify? And do we have that video that we can?
So something was sent to the exhibits while we were on the dais.
Yeah.
Print it, it was supposed to be in ahead of
I know. I didn't know this was going to be an issue. I've got a picture of it on my phone. It's pretty simple stuff. It's a couple of people really close together.
And is at the time that the service did
Yeah.
occur?
Okay. So like I say, it's just different. It's not something I've seen before in almost 2 decades.
Okay. Sure.
And so I don't know. I just want to finish my argument. I don't know if Uncle Joe's buying the beer or if Cadet Lily's buying the beer. When I go on with somebody who looks to be about twice the age of the cadet. And it's just it's tough, especially as you can see from that photo. There's a lot of people in this bar. It's not like an empty place. So it's just different. That's all I'm saying.
Are you claiming that that the cadet wasn't served the Corona, what is this, a $6 instead of a $9 Corona this time? The Corona was put not in front of our Cadet Lily, or
No, I'm effectively saying guilty with explanation.
and Cadet Lily's here right now, correct?
Yes, sir.
Okay. And do you remember being served on that night?
Yes, sir.
And was the beer placed in front of you, or were you personally served?
Yes, it was handed to me.
Can you speak up, please?
It was handed to me, sir.
Okay. And was somebody with you at the time?
No.
Okay. You have something to say?
Yeah, I just wanted to clarify the omission of a deputy's name. One of the deputies is known to us and is in our sealed reports, just like some criminal investigation UC work. We are not naming that deputy for undercover operations that he performs other than liquor board stuff, and his identity cannot be identified in public.
But all the other deputies here today in these cases are named.
They're not undercover deputies. They're just working with the liquor board. They're not assigned to other federal agencies, working with task forces and so forth.
Right, but that's not explained in the report at all, is it? That it's an undercover deputy.
That's the reason.
There's a reason for that. Yeah, like I say, I just think it's, look, I know the Sixth Amendment. You know the Sixth Amendment applies to criminal cases. All right, but it smacks of a Confrontation Clause violation.
Do you have any questions for the cadet?
No, I don't. Thank you.
All right. Mr. Chair, I will note on the record that since we have begun the partnership with the Neighborhood Services Unit, a deputy has accompanied the cadet on every operation in every single one of these cases. So there was a deputy present, whether they were captured on camera or not.
And why is that?
For their safety.
Did you have problems with safety in the past with a cadet? I've been doing these 401A cases for decades.
That may have predated me. I can only go since we started the partnership with the NSU, which happened, as I was hired.
Okay, thank you.
Any questions, Commissioner?
No questions.
Yeah, any more argument?
What's that?
Do you have any more argument?
No, not at this time.
Okay.
No questions.
Questions? I love the argument. But based on the charging documents, the testimony that was given today, the proffer and the argument that was given by counsel, the excellent argument that was given, and the exhibits that were given, we looked at the picture. I initially thought that you were saying that maybe someone from the sheriff's office was beside the cadet at the time, and the bartender was confused. I thought that was your initial.
That is what I'm still contending.
And the cadet is stated on the record that he was there by himself, and the beer was handed directly to him. So that's.
I mean, I didn't ask, the sheriff's office to confirm or deny that the person standing to the right works for the sheriff's department, especially after they tell me he's undercover.
Yeah.
So
is that something you want to know? Or?
No, I mean, no.
Oh, okay. I do see that this is. I do see a violation of Rule 4.011, sales to minor. I don't see any other violations that are similar. I would issue a $250 nominal fine on this.
Well, I just want to at least mitigation, not argument mitigation.
Yes.
Yes,
go ahead.
Yeah, and I'm sorry because it's past my lunchtime. I got up early, breakfast before sunrise. This is a great operator. As you can see from the record, first offense on any kind of minors. There was some kind of festival 2 years ago, and there were a couple of people out front drinking open container. But I do want to just let you know this because I think this is brilliant. I'm going to recommend other clients to do this. You always hear, we fired the guy, or Jeff Danik, who I've known for decades, does something that I think is really great because he doesn't, if it's a good employee and it's a first-time offense like this, he doesn't want to fire the guy. But what he did was he took this employee, Mr. Dorix, and he gave him a month probation. He suspended him for a week, no money, no pay, because there should be consequences for these things. And termination isn't always the way because then you hire another person who doesn't get it, and then they're going to sell to a minor. But in this case, I like what he did. He gave him 1 week suspension without pay, and then he brought him back for a month on probation with no alcohol service, doing bar back and stuff like that. It made him work his way back. And guess what? Mr. Logan Dorix is going to remember that, and you're not going to see his name if there's ever a violation here again. So I commend him for that. So again, first offense, I'd ask that you consider all that. Thank you.
Oh, yes. I think that's great. That's something that I think other licensees should do. And he is going to remember that and probably not do this again because it hit his pocket and he had to work his way back up on it. Given that mitigation, I will adjust the fine to $200 on the sales to minors. It's a nominal fine. You're not going to be here again. Your attorney did a great job, but I still think that was a violation, and 30 days to pay the $200 fine.
Council, on the day you really earned your compensation, but I do find a violation of Rule 4.011, sales to minor, with a violation of $200 and 30 days to pay.
I also find a violation of Rule 4.011, sales to minors, on February 11th, 2026, and impose a fine of $200, 30 days to pay.
Those are just for the record. Violation report, number 1, Inspector Jordan.
Thank you for your indulgence.
Thank you.
Alton C. Peoples, Deepak Pudel, and Manju Ranabat, SBD Group, LLC, trading as Liquor House and Bar, 3 East North Avenue, Class BD7 beer, wine, and liquor license. Violation of Rule 4.011, sales to minors on March 2026, and violation of Rule 4.011, sales to minors on March 2026. Please come forward.
Good afternoon. How are you? Is
Good
this going to be an admission?
Yes, we're considering admission.
Okay. We can go ahead and tell us what happened briefly.
Yes, Agent Perez, Baltimore City Liquor Board, on March 20th, 2026, approximately 11:12 p.m. Myself, along Agent Hope, Chief Inspector McGinnis from the Baltimore City Liquor Board, and members of the Sheriff's Office Neighborhood Services Unit conducted underage sales compliance investigation throughout the city. At the time of the investigation, Cadets Martin and Washington were both under the age of 21, proceeded inside of the establishment known as Liquor House and Bar. Once inside, they both completed separate purchases. Cadet Martin purchased 2 cans of Bud Ice beer for a total of $4.50. Shortly thereafter, Cadet Washington purchased 2 cans of Modelo beer for a total of $4.50. Both transactions were completed using previously marked $20 bill from the store operator, who was later identified as Mansell Bassnet, date of birth 1/28/2005. After completing the purchases, both undercover deputies and cadets, after completing the purchases, undercover deputy and cadets exited the establishment and confirmed they had successfully purchased alcohol beverages. Moments later, the rest of the team entered the establishment and advised Mr. Bassnet that he had sold alcohol to an underage individual. Mr. Barnett was informed that no criminal charges will be filed. However, a liquor law violation will be issued against the establishment. All products along the change were returned to the operator, and the $20 bills were recovered. No further incidents.
Thank you. Cadet Martin? Yes, sir. And Cadet Washington? Okay, thank you, guys. And like I asked other cadets, you gave the Bud Ice and the Modelo back?
Yes, sir.
Okay, that's good.
Just a simple question. Was Mr. Bassnet polite and cooperative?
It was.
Thank you.
Okay.
Commissioners, first of all, JU representing the licensee, Mr. Patel, who's stand to marry. Mr. Patel's apologetic for what has happened. We could try to explain on behalf of Mr. Bassnet as to why this happened, but of course, you have heard it all, and I'm going to keep it very quick and simple. He's apologetic, and the question is how to not to have this incident happen again. And obviously, Mr. Bassnet is no longer employed with the establishment. He terminated the individual. So, Mr. Patel, we discussed, and the best way to make sure that this doesn't happen again is to have all his employees, including the part-timers, Mr. Bassnet was a part-timer, have them certified in alcohol awareness training, and then have Mr. Bassnet install some kind of in-house training program to refresh them, because even after they get trained by the instructor, they tend to forget and they get lazy, and they sometimes, as you know, when you ask for ID, some customers complain and whine and try to start an argument with you, and sometimes part-time employees, they just don't want that, so they get lazy. So idea is to have Mr. Patel train his employees bi-weekly so that they're reminded. They have a meeting before the work starts or their shift starts so that they will be reminded, and also install some penalty program, like as Mr. Fogelman mentioned, so that there'll be probation and then suspension and then termination. Mr. Patel, in this case, I think he just didn't care, so it was pretty obvious that he should not belong at this establishment, so he was terminated. So Mr. Patel will come up with those structured programs to train his employees and monitor his employees. It's very important to monitor his employees, and he learned his lesson. Thank you.
Thank you. Any questions, commissioners?
No questions.
Okay, based on the charging documents, testimony that was given today, and proffer made by counsel, I do find a violation of Rule 4.011, sales to minors, and another violation of Rule 4.011, sales to minors on March 20th, 2025. I don't like that it's 2 violations at the same time. I don't like that, and you do have prior violations. One's a while ago, 2022, the other one was in 2025. I do love that you're proactive in this. I do love that you guys are making steps to make sure this doesn't happen again. But based on the record, The fine would be $300 for each of the sales to minors. And hopefully this won't happen again. I don't see any other sales to minors in the past. This is the first time and hopefully the last time. But when you get that double whammy at the same time, you know, that shows that your staff is not trained. And this is one of the things that we're cracking down on in the city of Baltimore. We need to make sure that we keep our young people safe. And we're very serious about that, okay?
Thank you.
I concur with the chairman on violation of Rule 4.011, sales to minor, on March the 20th, and the repeated same one for violation of Rule 4.01, sales to minor, each proposing a fine of $300 each for 30 days of pay.
I also find a violation of Rule 4.011, sales to minors, an additional violation of Rule 4.011, sales to minors, impose a fine of $300 each, total $600, 30 days to pay.
Michael exhibits for the record. Board Exhibit 1, violation report, Agent Perez, 2 through 3 photos.
All right, thank you. Good luck.
Thank you.
Una Karki LLC, trading as Broadway Discount Liquors, 628 South Broadway. Class BD7 beer, wine, and liquor license. Violation of Rule 4.011, sales to minors on March 21, 2026. In violation of Rule 4.011, sales to minors on March 21, 2026. Please come forward.
Good afternoon. Stephen W. Fogelman. I'll be brief, not responsible.
Okay.
Agent Perez, Baltimore City Liquor Board, on March 21st, 2026, at approximately 12:52 a.m., Sheriff's Office Cadet Martin and Washington, both who were under the legal age of 21, proceeded to the exterior of the establishment known as Broadway Discount Liquor, 628 South Broadway. Once inside, both cadets completed separate purchases. Cadet Martin initially purchased 3 cans of Bartenura Moscato wine for a total of $16.32. Shortly thereafter, Cadet Washington completed a second purchase of 3 200-milliliter XXL wine for a total of $16.57. Both transactions were completed using departmental $20 bill that were previously marked from the store operator known as Home Tapa, date of birth 5/23/1996. After completing the purchases, the undercover deputy and cadets exited the establishment and confirmed they had successfully purchased alcohol beverages. Moments later, the rest of the team entered the premises and advised Mr. Tapa that he had sold alcohol to an underage individual. Mr. Tapa was informed that no criminal charge will be filed. However, a liquor law violation will be issued against the establishment. All purchased products, along with the change, were returned to the operator, and both $20 bills were recovered. Nothing further to report.
Thank you.
Thank you, Agent Perez. You've been a part of this agency for years, isn't that right?
That's right.
All right. And is doubling up something that you've done throughout your career here?
I've seen it happen.
Seen it happen?
Yes.
Not very common, though, right?
It's rare.
Okay. Thank you. That's all I have. I mean, that's all I have as far as questions. I just, look, I want to say, and yes, the sales, you know, we're not denying the sales. This is just how the procedure works. This agency for decades has been known as tough but fair. And what's happened in the past is that duplicative or very similar offenses on the same date near the same time have been merged for sentencing purposes. And not 401s, because we don't see a lot of double 401s. It's usually like, the sanitation safety. There's an overflowing trash can. There's the sinks messed up. And then you would merge them to one. The reason for that is because, and as you can see from the record, there was a sale in 2022 and a sale in 2024. And now, if they get this double sale in 2026, now that's 4 offenses. And then let's say they go 5 years with no problems. Nobody's going to remember this, but they're going to say, this is your 5th offense. And so
These are consequences that are going to go down the road for decades, potentially. Let me just say that on the way to Liquor Board this morning at 9:30 for hearings, I had a Baltimore police officer behind me for many blocks on Eastern Avenue. And what if I was speeding as I sped past Wolf Street, and then I sped past Ann Street, and I sped past Washington Street, and I get pulled over, and I get 3 tickets for speeding because I was speeding that whole way. And so it's just, it feels to this extent. Why 2? Why not 10? Why don't we send in 10 cadets? And until they card, you might have 8, 9 offenses. I just, you learn from one. It only takes one. If deterrence is the reason we do this, then it only takes one to get the point across to the employee that you need to check IDs. That's all I'm saying. Thank you very much.
I understand that. It takes only one to get the point across, but you're saying to an employee, but this is a third sales to minor. So it's taking multiple ones for your client to understand. And I get your argument with merging. This happens a lot. I think it's a little different when it's 2 different. Like if the sale was to the same cadet on the same night, 2 beers or 2 Moscatos, I think that argument works a lot better. But with 2 individuals that were served on the same date, that's 2 times that they didn't do what they needed to do to make sure that they were under the age of 21. But I mean, I agree with you on taking that into consideration when it comes to the fine. The last fine, I'm not going to go above the last fine. So I do find a violation of, any questions, Commissioners, before I go ahead and make my ruling?
No questions.
No questions.
Follow the protocol. I do find a violation of rule, because of your Rule 4.011, sales of minor, and violation of Rule 4.011, sales of minor, for the 2 cadets on March 21st, 2026. Last time was a $500 fine. I would issue the same fine for both of them, a $500 fine, and not go up as we normally do, go up in fine amount. So it's a $1,000 total fine. I do understand it's 2 on the same date, and that is not the normal policy that's been done in the past, but it's being done now. So, in 30 days to pay.
I concur with the chairman on violation of Rule 4.011, sales to minor, on the same exact date, 2 separate fines in the amount of $500 each, a total of $1,000 with 30 days to pay.
I also find violation of Rule 4.011, sales to minors on March 21st, and an additional fine of violation of Rule 4.011, sales to minors, with a fine of $500 each, 30 days to pay.
Ms. Russell.
All exhibits for the record. Board Exhibit 1, violation report, Agent Perez, 2 through 5 photos.
Thank you. Thank you.
Vincent On and Stephen Bain Morgan, 6001 Bel Air Road LLC, trading as Hubcap Inn, 6001 Bel Air Road, Class BD7 Beer 1 and liquor license, violation of Rule 4.011, sales to minors on April 8th, 2026. Mr. Chair, there are members of the community that wish to address the board after the inspection team testifies.
Okay. At some point, we may need to take a 5-minute break. Does anybody need? This may take a little while. Can you guys go until after this one, or are you good?
We can do this.
Okay, after this one, we'll take a break. Okay?
For the record, Melvin J. Konecki, representing the licensee.
Is this going to be an admission?
I don't have any curveballs. I don't have anything I could say. This will be an admission.
Okay. Go ahead.
Inspector McCullough, Baltimore City Liquor Board. On April the 8th, 2026, approximately 6:46 p.m., myself, Inspector Bass Myers, and Chief McGinnis, along with the members of the Baltimore City Sheriff Unit, Baltimore City Sheriff Department, went to the above location to conduct an underage operation. Sheriff Cadet Lilly, under the age of 21, accompanied by an undercover sheriff, was served a shot of Tito's using a departmental marked $20 bill. The shot cost $6.54. The cadet and undercover sheriff departed the establishment and notified the team of the buy. We entered the establishment to notify the licensee and bartender, identified as Mr. Thomas Ross Jr., that he sold alcohol to an underage cadet. I advised the violation would be written. Sheriff retrieved the marked $20 bill, and we left without further incident.
Any questions?
Yeah, do you know where they got the $20 bill from when they got it and retrieved it?
They retrieved it from the register.
You sure?
That's where the guy gave it to us from.
Okay. No further questions.
No further questions?
No.
Okay.
This, on behalf of the licensee here, this is the first offense for this license. I know that there was some assertion that prior, a few years ago, there was a separate corporation, KN, and this is a different corporation, different ownership under the Rosedale case. There seems to be some confusion because if you look at your docket, in fact, it says licensee KN and Inc., which is not this one, although I'm not making an issue of that because when they issued the summons was issued to the right LLC. So if you look there, it says KN and Inc., which is not this licensee. The individual in this case he had some problems with the licensee. They caught him taking monies that weren't his own. He was taken, and he's since been fired. He's had the particular place, and other people come out being alcohol certified. They're going to some training and so forth. So,
Are you saying the transfer occurred
24.
23? Or
I'm looking at your docket.
Yeah. So you're saying that the past violations that are in front of me, the 2013 to 18?
That's for different corporations, for KN and Inc., not for the 6001 Blair Road LLC.
I'm going to have them look into that. Can you guys look into that so I can make sure I rule appropriately? I do see a 2023 transfer.
Correct. The other corporation went through a bankruptcy, and as a result of which this new LLC became the owner-operator of it. So this is the first violation for this particular location. Same theory. Now, it occurred to me, and I think it's interesting when you do look at it, you could have a licensee who would be on 5 licenses, Bs. And there's something happens on 2 or 3 of them, all different entities. Well, they're all different entities. That's the reason why you do the different entities. You can't put on one all the other things that happen on the other place. So in this place here, this is a new entity. This is the first violation. They've taken steps to rectify it. And in fact, they have to discharge the employee who they caught taking money they weren't supposed to, and has had the other people certified that are working there and making sure everybody gets checked. Apparently, it was a year or so ago they got a letter where cadets came in, they weren't served. We used to call those good boy letters in the old days.
Okay. We got members of the community that like to...
I don't want the community to say anything until after you make your disposition, because it has really no part in this part of the proceedings. I think it's going to mess some record up. Respectfully, because if they weren't there when the sale was made, and we're here on that violation, what they have to say has to do with something similar.
Let me see at least who's here. Don't testify yet. Just tell me your name and who.
I'm the president of Sedmont Community Association and the board of director of Harbel. My name is Kiana Hextall.
Pastor Christine Parker, pastor of Epiphany Lutheran Church up the street.
Okay.
And that's my security officer husband.
Shawdo McKinney, just a resident of the Sedmont community.
And her security. Okay. All right, so we have 3 members of the community. Any questions, commissioners?
No, I don't have any at this point.
Do you have any questions?
No questions.
Okay. Ms. Wordsworth? you guys look up to make sure that the transfer did occur and that this is a separate entity that holds this license? And
Sir, I'm not sure how that mistake was made, and if it is your wish, we can hold the case and reissue a summons with the correct corporation name.
The summons was correct. Your summons that you sent out was correct, but your docket has K-Ann Inc. in it.
so the issue that I want to make sure that we have is that the prior violations, as I've requested, and we always have, we want to look at, that I want to have in front of me, that happened on 2021, 2018, 2023, and in 2012. If this was a different entity and a different person that was running the establishment than this one, I don't want to consider those past violations in my ruling now. So that's what I need to figure out. It sounds as if it may be a different.
If your docket says the license transferred to the above entity on 3/21/24, the prior entity was K-Ann Inc. This one here is the other one. It says, however, Mr. Prince was a licensee, but that goes back to the same theory we had before. If you could be on 4 or 5 licenses, you can't hold what happened on the other license to this particular entity that's here.
You can hold the individual accountable, and if he's on both of the licenses, when the bad act happens, you can take that into account.
Well, then you should start finding individuals instead of the licensees who are the corporations. If you want to start doing that, I'm okay with it, but you don't do it that way. It's not the way the law is
So
written.
let me just ensure. When did your client? So was your client on the previous license?
Previous license.
From the beginning, from the inception of it,
Well,
of the entity?
he was on the K-Ann Inc. He is the licensee after that went through a bankruptcy on this license here, which is 6001 Blair Road LLC, right?
So he started the new LLC after he went through the bankruptcy.
Right.
Right, okay, that's fine.
Yeah.
Thank you. It's clear.
I have one question.
Go ahead.
Council, we have people taking off from work today from the community. Is there a reason why you think the board would be impartial to not hear what they had to say?
Not until after you make your disposition. If it has something to do with this violation and they have a knowledge, it should go in the record. If they have something else they want to say otherwise, then after you make your disposition, if you feel that you want to hear from them, then
I'm gonna instruct them prior to us making it. You have any questions?
No, I don't have any questions.
Was anyone present during this incident on April 8th, 2026? Did anybody see what happened or have any knowledge about
No,
this incident?
no.
No? No?
We have knowledge, but we weren't there. We
You weren't
wasn't
there?
present, yeah.
You weren't present? Okay. All right. So we're gonna make our ruling and then we can hear from you, okay?
Okay.
I agree with counsel on that. Based on the charging documents testimony that was given today, apart from by counsel, I do find a violation of Rule 4.011, sales to minor, on April 8th, 2026. I do, in this case, issue a $750 fine for the sales to minor. I did hear your argument, and that's an independent, I don't have to say right, 30 days of pay.
I concur with the chairman on his ruling of $750 with 30 days to pay for violation of Rule 4.011, sales to minor.
I also found a violation of Rule 4.011, sales to minors on April the 8th, 2026, and impose a fine of $750, 30 days to pay.
Go ahead. State your name again for the record.
Absolutely. Again, I'm Kiana Hextall. I'm the president of the Setmont Community Association, and I am also a board of director at Harbell. And the reason that we are here today, although we're not, we wasn't present for this incident, this establishment is a major disturbance to the community. There's several 311s on file, several 911 calls to this establishment. There's also been several criminal calls and incidents at this community, 2 of them being resulted in murders, with those folks being customers from this establishment. In addition to that, they're very noisy, very trashy, and the trash comes into the community. Also, across from this establishment is a Dunkin' Donuts. We believe that Prince Anand, who's the licensee at Hubcap, is either in relation with the licensee at Dunkin' Donut, or they are very good friends. So on nights where there's parties or a fight, MMA, wrestling, they utilize that parking lot as an overflow parking, and that trash ends up in the community immediately. The residents have to get out and clean. Even the owner at Starbuzz, which is to the left of this establishment, come out and we clean the trash from this establishment. We also end up with folks that are drinking outside of the establishment, and there's a bus stop going north Bel Air Road, south Bel Air Road, with folks drinking and partying, and folks cannot stand on the bus stop to get to and from wherever they are going. I've also had to reach out to Mr. Anand several times about the overflow of his dumpster, about the illegal use of the building behind him that is attached to the establishment. We also have witnessed drug activity. Also, the security that's outside of this establishment is partying and hanging with the crowd that's disrupting the community. So although we are not a part of this incident, we did want to get on record to let the board know that this establishment is a major disturbance to the community, and the community does not patronize this establishment. Also, alongside that building, there's a no parking. One side is parking, one side is not parking. When this establishment has parties, you better believe that no parking side is full of cars. I've sent him pictures of that. Yes.
Have you talked to your
Yes.
delegates,
Yes.
senators?
Delegates, Councilwoman Danielle McCray, Senator Corey McCray, Sergeant Hardy, Officer Cooper, all of the things. We've done those things, but we wanted to make sure that we got on record today, and we will continue to come every time we find out that this establishment is on the docket, because this establishment is diminishing the community. If you are familiar with Sedmont community, it's a very nice community with middle-class folks, very diverse community, but this establishment brings a negative crowd to the community. And I'm also familiar that Mr. Prince owns a restaurant in Hunt Valley, and none of this is tolerated there. None of it, because they would put him right out. And he does not.
I don't know
And
why.
he does not.
Can I object for the record?
And he does not behave like this as it pertains to Hunt Valley. So I did want to ensure that we got on record today, and we'll continue to come.
Thank you.
Do you want me to ask a question on dates, times, places? Oh, wait a second. I mean, what happens in Hunt Valley, you see what happens with all these cases. They start dumping from other places. If there were murders, can I just ask you, when were the murders?
Okay.
And just let the lady testify. Don't whisper in her ears. When were the murders? When were the murders?
She did not associate. No, she's not testifying, and she did not say that a murder happened in his establishment, and we're not going to take that into consideration as if the murders are happening.
I'm sorry, I don't have any question.
We're not. I understand what you're saying on that. But I do.
Wait.
But he does need to know what's going on and the spotlight, and if they're going to come every time that there's a violation. So
Well, then we'll bring up 40, 50 people. If that's okay, that's what they're going to say. And you're going to have the same thing. We have that.
6 restaurant, best restaurant awarded in whole America.
all right. So
If she
you
calls
have to raise your right hand if you're going to say
I
something.
can. My name is Prince Anand, and
Go ahead.
Do you swear or affirm under the penalty of perjury that the answers and statements that you give are the truth, the whole truth, and nothing but the truth?
I do. Yes. My name is
Can you state your name?
State your name.
with Prince Anand.
And we want the community to be heard in these cases. That's why I let him talk.
Yes,
But,
sir.
Mr. Chair, if you know that's going to be the case, and we know, he should have the opportunity to bring his people also, so if it's contrary, you cannot believe one person over someone else unless you have contrary evidence. That's all I'm saying. Okay?
Mr. Chairman, with all respect, I have two sons, one is 18, one is 22. I have 6 restaurants, best awarded restaurant. If Miss Kiana calls me middle of night, 2 o'clock, not weeks, not days, not hours, within a minute I respond and I send a video what I did. I live in Baltimore City. Baltimore, from Mr. Brendan Scott to everybody, they were the same councilman there. Miss Linda Cruz was president there. He came here against me. I was part of every day. She texts me at least once a week. I respond within seconds. 2 o'clock, I sometimes respond, sir, man, I'm in India. Respond within a second. And after that, I be honest with you, I feel sometimes harassed. You know, I respect that. I'm Baltimore City. And she says, oh, they're not my relatives. That's a relation. Sometimes, and I present, they have a cash from 7-Eleven, from Dunkin' Donuts to everywhere. Each block in Bel Air Road, there's the, if I can control, you can ask there, Mr. Sheriff there, because there, how I control my communities. I don't drink myself. I understand. I'm not disrespecting the people drink. But at the same time, I feel harassed. If she tell me I can bring 200 people here, this happened. Why Miss Linda Cruz was never here? She was present there for maybe more than decades. She has a good relationship with me. Each time they ask me, I come there. But when I feel embarrassed because they treat me like I'm a criminal there. My son go to UPenn, my other son go to NYU Stern. I teach my kids. I tell my community to how to behave with others. But I can't control. She texted me day before yesterday. Somebody did they do mattresses, they everything. How committed to them to me? They never take any action. Did she call 311?
Standing from the mic.
She never called 311 on my behalf because I'm not part of the community. She just sent me the picture. Oh, in your property, somebody dumped something. I responded within a second, sir. Middle of night. If something happened, and then I see it's not major, I understand because somebody dumped, whole air conditioning unit, and my dumpster is my fault, sir. If I take full responsibility. Did I respond within a second? She told me one time, your trash is overcrowded. I think there was some obstruction there. I sent a video within a minute. I arranged $1,000 dumpster to come and pick it up. Did I, ma'am?
You did.
Thank you.
I understand the community's concerns. I understand the licensee's concern. I don't want this to get more out of hand. It seems as if you both want to coexist and want to figure out a way to coexist. Do you guys need any help from our office? Do you need any mediation in our office?
Absolutely.
Okay, so I'm going to dismiss you guys now because this is going to be one of the longest hearings we've ever had. But I know everybody wants to be heard. Matt, you back there? Can you please talk to him in the hall and make sure?
No, we are fine.
What'd you say?
I said we are fine.
I know, but we have somebody
Somebody from the liquor board.
from our office that can mediate with you guys. So maybe we won't be in this situation in a couple months from now, okay? All right. Thank you for testifying, or at least explaining what from your perspective. Thank you for giving your perspective on the record.
That. Thanks for your time. I do appreciate and really, thanks for being patient.
And thank you, counsel, as always.
Thank you.
Thank you. All the exhibits.
Ms. Russell.
Medical exhibits for the record. Board Exhibit number 1, violation report, Inspector McCullough. Exhibit number 2, photos.
We're going to take a 5-minute break.
Oh, my goodness. Guys, you don't need a bottle of water or anything?
No, sir.
Good? Anybody, bottle of water?
No, for real. Oh, brother. Which one are we on?
So this, dates below the violations.
said they got off the station.
Ready?
Oh, yeah. You gotta have some.
Michelle?
Yep.
Let me know and I'll announce we're back on the record.
All right, we're ready.
Okay, we are back on the record at 109.
All next case, please.
This is Sheila Best and Oksana Karki Pudel Investment, Inc., trading as Stock Market Bar, 3538 South Hanover Street, Class BD7, beer, wine, and liquor license violation of Rule 4.011, sales to minors, on April 8th, 2026. Violation of Rule 4.204B, prohibited activities by license type, on April 8th, 2026, for failing to open the tavern area for on-site consumption, and violation of Rule 3.033 records on April 8th, 2026, for failing to provide employee records. Please.
Good evening. We've been here all day.
Good evening, Jay. You're representing the licensee, Ms. Karki?
Is this going to be admission?
Yes, it is admission.
Okay, good. Go ahead, give us a brief statement, please.
Inspector McCullough, Baltimore City Liquor Board. Myself, Chief McGinnis, along with members of the Baltimore City Sheriff Neighborhood Service Unit, went to the above location to conduct underage BD7 operation. Undercover Sheriff and Cadet Lilly entered the location and was denied entry to the tavern. Undercover Cadet then purchased a bottle of Mango XXL wine totaling $9.80 using a departmental $20 marked bill from the packaged good window. We were once notified that a purchase was made, then we all went to and advised the store employee that he sold to an underage cadet and that he denied undercover sheriff entry to the tavern. While Sheriff Chris Amalis was interviewing, he asked the employee for ID, and the employee advised that he didn't have any. I asked for employee records, and he could not provide them to me. The employee gave us a name of Sanskur, sorry if I'm pronouncing it wrong, Sangrula. I advised the violation would be written for sales to minors, tavern not operational, and employee records, and we left the establishment without incident.
Any questions?
No questions.
Okay, go ahead, any mitigation?
My client had taken over this business, actually complete the transfer, and then about into 3 months, this incident happened. She was still learning the business, and of course, there is no excuse for that. That is the precise reason why she underwent alcohol awareness training herself to learn the rules and regulations. So my client is not trying to give any excuses as to how and why this happened. There is absolutely no excuse. She will make sure that all our employees are certified in alcohol awareness training. Not only that, she will train them and teach them the essential rules that they need to know as either manager or as an employee. For instance, the record keeping and making sure, knowing where the records are kept and make sure that all those records are readily accessible to the inspectors and to abide by all the rules and regulations. I think that's something that she failed to do. So this being the first offense, it's respectfully requested that my client be given a leniency in this matter. Thank you.
Yes, I understand. And it is disturbing that on January 9th, 2026, an application to transfer ownership happened. So
yes.
Very, very recent. And one of the things that we do discuss a lot of times when transfer does occur, we ask what the licensee is going to do to make sure that their staff's going to be prepared and so that this doesn't happen in the future. Sorry, this is a rude awakening, I guess. But any questions from the other commissioners?
No questions.
No questions.
Okay. Yeah, based on the charging documents, the testimony that was given today, the proffer that was given by your counsel, I do find a violation of Rule 4.011, sales to minors, a violation of Rule 4.204B, prohibited activities by license type, and a violation of Rule 3.033, records on April 8th, 2026. I do issue a $250 fine for each one of those violations. This is your first run at violations. Hopefully, you'll take those steps that your counsel stated. You won't be here again. As you know, the fines go higher, the more violations you get, all the way to suspensions and revocation of the license. So please take this seriously, okay?
Thank you.
I concur with the chairman on violation of Rule 4.01, sales to minor.
Wait. My ruling doesn't count all the way. This is a vote.
I'm sorry.
They could say something different than what I.
Violation of Rule 4.204B, and violation of Rule 3.3, records, all each $250 fine with 30 days to pay.
I also find a violation of Rule 4.011, sales to minors, a violation of Rule 4.204B, prohibited activities by license type, and violation of Rule 3.033 on records with a fine of $250 each, total of $750. Being a new owner, licensee, I would suggest you take advantage of the resources we have here to understand really what your license covers and what it prohibits. Okay? Thank you.
So much, Ms. Russell.
Medical exhibits for the record, Board Exhibit Number 1, Violation Report, Inspector McCullough.
Good luck.
May I be excused?
Yes, good luck. You don't have to ask that. Next, please.
Roderick Leon Graham, Mamata Ranjikar, NMP North LLC, trading as Robbie's Nest, 2250 East North Avenue. Class BD7 beer, wine, and liquor license. Pardon me. Violation of Rule 4.011, sales to minors on April 8th, 2026. Violation of Rule 4.204B, prohibited activities by license type on April 8th, 2026 for failing to open the tavern area for on-site consumption when the packaged goods area was open. Violation of Rule 3.081B, sanitation and safety for an individual smoking inside the establishment, and violation of Rule 3.02A, cooperation on April 8th, 2026 for employee giving a false name to staff. Please come forward.
Good afternoon.
We were going to fight it, but we know Steve's still coming up, so you guys got a long afternoon for you. It's going to be an admission. Did we need to have the commissioners testify, the inspectors testify in any capacity, or we?
No, I like them to put on the record what happened, at least, and then move forward. That's all. Brief statement, please.
Very well. At approximately 7:27 p.m., Undercover Sheriff Lane and Cadet Lilly entered Robbie's Nest located at 2250 East North Avenue. Deputy Lane attempted to enter the tavern but was advised that it was closed. Cadet Lilly purchased cherry limeade beatbox for $4.35 using a departmental marked $20 bill. Cadet Lilly and Sheriff Lane departed the establishment and notified the team of the purchase of alcohol. BLLC and BCSO staff entered the establishment to notify the licensee and bartender that he sold alcohol to an underage cadet. The manager on duty, Mr. Kamali, initially gave a false name and was very uncooperative. Once Sheriff Crystal Malice stepped in, and only then did Mr. Kamali provide a physical ID with his actual name. Mr. Kamali attempted to convince staff that he had two separate names. There were also patrons smoking and gambling inside the establishment. Inspector Bass Myers advised Mr. Kamali that he would receive several violations. The sheriffs retrieved the marked bill, and all staff departed the premises without further incident. I'd also like to add that I have been their inspector in the past, and I noticed that the back was not operational, and I brought that to their attention. They assured me that it was indeed operational. So to be on this task force and see it indeed closed is a concern. Thank you.
Thank you.
Thank you.
So again, this is an admission. I spoke to my clients about the tavern issue, which I think is a repeat of a previous violation. My understanding with this incident, and again, it certainly sounds like this is perhaps not something that this is the first time this has occurred beyond the other violation. The incident in question, my client indicates that two individuals approached the door where the tavern is, and it's kept locked normally because they don't want people drifting in and out. They want to try to control the crowd in and out of the bar. And when the door was noticed to be locked, one of the individuals banged on the door, and that kind of caused some concern for the clerk at the time. Again, I'm not saying that this was any sort of issue in terms of improper investigation. It just caused the clerk in question to be a little concerned about the situation, at which point he told him it was closed. The inspector's testimony seems to indicate that this is a regular issue as opposed to a one-off. I did have an extensive discussion with my client about the fact that the bar has to be open all the time that the location is open, and there can be no exceptions. There has to be people to go freely between the two spaces. I think that and the sale to minors are the two kind of biggest issues. I haven't had a chance to speak to this individual who was working there, but I did talk to, again, the licensee who is with me. My understanding is some people have concerns when addressing law enforcement, given recent immigration concerns in the area. And they are sometimes apprehensive about providing their real information. I think that's the circumstance that occurred here. It doesn't excuse the behavior. The person did give that information over. My client does have the payroll records with them, as well as their alcohol awareness certificate, which is current and up to date. So the records do exist. The person is on payroll. I'm not sure where the confusion is. It sounds like this person was just very much thrown off by the whole situation, the clerk that was there. With regards to the sanitation and safety, they're working on all these things. The smoking inside, I talked to them about it. They said they haven't noticed it, but sometimes patrons are going to do whatever they can to get away with things that they shouldn't. And they're going to do a better job of monitoring that so people aren't going to be smoking inside anymore. Ultimately, the discussion led to the fact that there are some changes that they're going to make in terms of the bar being open. They're going to do much better in terms of sales to minors. It's disappointing that one thing occurred and then another thing immediately thereafter at the same time. They plan to address these issues, and they're currently in the process of doing that. There's not a lot of good excuses to these violations at a location like this, but again, they're trying to make changes. They've only been in business for a little while. It's not a good start, but they're trying to do better.
Yeah, I feel like your client's been in front of me a few times from just the recent transfer in 2024, I think it was.
I think the transfer was in 24,
Violation.
about 6 or 7 months ago.
And then here again, because I'm recognizing, you know, I know this is something that you don't want your client to keep coming back before us.
Yeah, and despite the fact that everyone here is wonderful, they don't really want to be here either.
Oh, yeah, yeah. We want to get out of here and not be leaving at 8 p.m. Okay, any questions from the commissioners?
Yes, I have one question. You mentioned changes being made. When will those changes be made?
I think the changes are just a matter of instructing staff and just better training, better discipline from staff. We would hope that that would occur and has already occurred. I'd like to tell you that if you went by today, the bar would be open, but I don't necessarily want to dare the inspectors in any capacity because it sounds as if, from my clients telling to me, they have expressed significant concern to staff about the bar being open and sale to minors.
It just sounds.
Sometimes it's just difficult with staff.
It just sounds open-ending.
What I can tell you is they're working on it actively. I try not to make promises that I can't keep. I try not to have clients do that either. That's the concern for me. I don't want to tell you this won't happen again and then be back here in 6 weeks because of a fluke issue or an issue that was unaddressed. So we don't like to do that. That's what it comes down to.
Need a different type of license?
License, yeah.
We'd love to get an A. You guys can approve that today. Whatever you want, no problem.
Any other questions?
No, that was the question I had. Chairman, yeah, but no other questions.
Based on the charging documents, the testimony that was given today, the proffer given by counsel, on the exhibits that we see here on the screen, I do find a violation of Rule 4.011, sales to minors, a violation of Rule 4.204B, prohibited activities by license type, and a violation of Rule 3.081B, sanitation safety, and a violation of Rule 3.02A, cooperation. I issue a $750 fine for the first one, the 4.011, sales to minor, $750 fine. And the second violation, I issue a $500 fine. That tavern issue is going to have to be rectified because they're just going to keep racking up these fees. The third violation, $500 fine for smoking, that shouldn't even be an issue in this day and age. What was this? Smoking cigarettes? Is that what it was? Cigarettes?
That's what the pictures seem to reflect.
And the fourth violation, the cooperation one, $500. And I think I'm being generous. You cannot lie to us when we come in, and you can tell that it's liquor board. You can tell it's the sheriff's office when we come in. I can understand your argument in these days and times, but no, that can't happen. So 750 for the first, 500 for the second, 500 for the third, and 500 for the fourth violation. 30 days of pay.
I concur with the chairman on violation of Rule 4.011, sales to minor, $750 fine. Violation of Rule 4.204B, prohibit activities of license type, $500. Violation of Rule 3.081B, sanitation and safety, $500. And violation of Rule 3.2A, cooperation of $500 with 30 days to pay.
I'm also in agreement in violation of Rule 4.011, sales to minors, with a fine of $750. I find a violation of Rule 4.204B, prohibited activities by license type, and a fine of $500. I find a violation of Rule 3.081B, sanitation and safety, and impose a fine of $500. And I find a violation of 3.02A, cooperation, and impose a fine of $500 with 30 days to pay.
Commissioners, could I ask if we could do 60 days? Would that be possible?
Yeah, that's fine.
Just in this circumstance.
That's fine.
No 60 days to pay.
Duly
I'm in
noted.
agreement.
Medical exhibits for the record. Board Exhibit 1, Violation Report, Inspector Bass, 2 through 7, photos.
Thank you, Commissioners. May we be excused?
Yes.
Thank you.
Good luck to you, okay?
Triana Canal and Daman B. Shah, You Pretty LLC, trading as The Point, 525 through 29 East Patapsco Avenue, Class BD7, beer, wine, and liquor license. Violation of Rule 4.011, sales to minors on April 8th, 2026, and violation of Rule 4.204B, prohibited activities by license type on April 8th, 2026, for failing to open the tavern area for on-site consumption when packaged good area was open and operating. Please come forward.
Thank you. Good afternoon, Stephen W. Fogelman on behalf of the licensee, Srijana Kamal. This would be a denial. I'll do it quicker than Mr. Hurdle did his admission. All right. First of all, we are joined here by the person who did the alleged sale, and we have a letter from the licensee permitting him to proceed in her stead. And I just want to go ahead and get that to you all right now. And while I'm here, I just
Thank you.
right. For some reason, I don't know why. It's probably in the file, and I'll submit another one. I'll submit them. But this is the email from the licensee indicating the consent will be.
Thank you, counsel.
Thank you for the employee to proceed here today, and I'll get you all that in a moment. Thank you. All right, very briefly, this will go quick. Thank you.
Okay, go ahead.
At approximately 9:50 p.m., the undercover Sheriff Lane and cadet entered the Point located at 525 Patapsco Avenue. Sheriff Deputy Lane attempted to enter the tavern but found it blocked and closed, with no staff behind the bar. Once inside the packaged goods area, the cadet ordered and received a bottle of Smirnoff Apple for $5.70. Payment was provided using a pre-marked $20 bill. The undercover staff then exited the establishment and informed the rest of the enforcement team that the cadet had purchased the alcohol and the tavern area was not operational. BLLC and BCSO members then entered the establishment and made contact with an employee named Ram Kumar Tamang. They informed him the underage cadet was sold alcohol. He was informed that no criminal charges would be filed, but that a violation was being issued for serving alcohol to an underage individual and for the tavern not being operational when the packaged goods area was open. The purchased product, along with the change, was returned to the operator, and the marked $20 bill was recovered. Once the violation was issued, all staff departed the location without further incident. Mr. Ramkumar Tumeng was very cooperative and apologetic. And I must say, this is my establishment, this is my territory now that I inspect. And when I do inspect, as you can see in the picture, that trash can is very close to where it is right now, as well as that caution sign. And I have informed them that it must be open and available to patrons.
Okay. All right. Questions?
No questions.
All right. Any other testimony? No.
All right, just argument. The licensee spent a lot of money fixing up this bar. In fact, you may remember, you were certainly on the board when there were some alterations done without approval, and they had to kind of open it up better. They usually have, try to have 2 employees there, so you don't have to shuttle back and forth. It's my understanding the bar does get used. There's not a lot of bars in that neighborhood, and it's one of the nicer ones. Something I want to point out here, again, and I made my point in a prior case, the photo showing the cadet and the sheriff sort of together. And quite frankly, that's not even the closest they got. I just grabbed that. And I think that is confusing to licensees. But guess what? It's the new way. But when you see Uncle Joe, I think I referred to him in the last hearing, who looks 40, and this other guy, it might be confusing, is, hey, I'm going to sell this. What they do with it when they leave the store, if Uncle Joe wants to split it with his nephew, it's up to them. And I understand that. But I also want to make it so clear, because I don't think in the prior case, when sugar was a little low, that I screwed up here, because I had video, both of the prior case and of this case, and I wasn't going to introduce it. But then when I was sitting there waiting around, I did screenshots. And I did not mean to imply in any way, shape, or form that staff had failed to get evidence into the packet. And in fact, I submitted this one at 11:10 a.m., 40 minutes after the hearing started. The other one I submitted at 10:43, 13 minutes. So that was on me, not the staff. I want to make that so clear, and I apologize for not getting it out quicker. So I want to say one other thing, because you were here, Chairman, and I'm not trying to be Mr. Nitpick today, but this one's hard when it shows the violation history, because there was this one hearing, but it doesn't show what was guilty and what was not guilty. And I know for a fact that this violation of Rule 3.01 was dismissed by Chairman Matriciani on that day, because I think at that time the cashier said, let me call the boss, let me call the owner, and he called the husband of the licensee. And so that charge was dismissed. I mean, you see, it's a $500 fine. What y'all got him for was the alterations. And I don't even think there was a fine for that one. I think because it ended up costing them like 12 grand to break down what they had done. So I think that the 500 was for the records and possibly for the open and operating. So I just want to say that. That said, they're going to make sure that the bar is open and operating at all times. And they were confused about the older gentleman and the younger gentleman, but it's a learning experience. I thank you very much, and that's all I have. Oh, but except I introduced it, so I might as well mention it. They had Mr. Tamang tips certified on May 13th, and it's so fresh that they don't even have a certificate to issue to them. That's what that email says. So thank you very much. And I appreciate you saying that he was polite and contrite, because these folks are really trying to do the best they can. And I appreciate your time.
Is it your contention that Cadet Lilly wasn't served, though, or he was served just with someone behind?
Not. It's not, but it's hard to say. I mean, this is, as you know, administrative hearing, but, not guilt beyond a reasonable doubt. It's very difficult to tell who got served, but obviously the testimony here and the violation report shows that, says that the cadet did the purchasing. So
that he did purchase it. Correct. You were the one that purchased the.
Yes, sir.
Thank you. thank you for your argument. Based on any questions, commissioners, before I take my ruling?
No questions.
No questions.
Okay, based on the charging documents, the testimony that was given, proffer made by counsel, argument, the exhibits that were entered into the record, I do find a violation of Rule 4.011, sales of minors, on April 8th, 2026. It is a first violation for sales of minors, $250 fine. Please watch it. Please watch it. We can't have this happening in the city at all. At all. Even if, as your counsel stated, someone standing behind that may be of age, you can't hand or allow any minor to purchase any alcohol in your establishment. You know that. And the second violation is of Rule 4.204B, prohibited activities by license type. The tavern violation that happened so many times, $500 fine for that. You guys got to figure that out, okay? So total's only $750. You have great counsel here today, but you got to figure out that, making sure that it's staffed. You can't have the trash cans there. You know, our inspectors are on to what's happening there. So every time they come in there, they're going to be looking. Okay? Commissioners?
I do find a violation of Rule 4.011, sales to minor, $250 fine. Violation of Rule 4.204B, $500 fine with 30 days to pay.
I'm in agreement. I find a violation of Rule 4.011, sales to minors, imposing a fine of $250. I find a violation of Rule 4.204B, prohibited activities, and impose a fine of $500 with 30 days to pay.
Medical exhibits for the record. What is exhibit number 1, violation report? Inspector Bass. 2, photo. 3, letter of consent to represent. 4, alcohol awareness training, email, and then 5, photo.
Exhibit 6, my apologies. Thank you.
Rushi Robin, Parika, I apologize if I mispronounced that, and Nama Pleva Saruni Inc., trading as Fireside North, 2201 West North Avenue, Class BD7 beer, wine, and liquor license, violation of Rule 4.204B, prohibited activities by license type, on April 8th, 2026, failing to open the tavern area for on-site consumption when the packaged goods area was open and operating.
Good afternoon, Mr. Chairman, members of the board. Peter Previs on behalf of the licensees. I have here with me today Mr. Niraj Shah, who is the brother-in-law of the licensee. She's in India on a pre-planned 30-day trip, but he has full permission and authority to appear, and we thought that we would take care of this. I also have Mr. Sean Johnson, who was the manager on duty at the incident. We deny the violation and request a hearing.
Okay, let's go ahead and proceed, please.
Sure. At approximately 8:34 p.m., the undercover sheriff and cadet entered Fireside North, located at 2201 North Avenue, to conduct an underage investigation. Deputy Lane attempted to enter the tavern but was advised it was closed. The rest of the enforcement team then entered the establishment, and Inspector Bass Myers informed the manager on duty, Mr. Sean Johnson, that he was out of compliance for not having the bar operational when the packaged goods area was open and operating. The team found boxes stacked on top of the bar, further indicating the tavern was not operated. Once the violation was issued, the staff left the location without further incident. And we want to note that they passed the underage investigation, and Mr. Johnson was nice and cooperative. Thank you.
Thank you. Inspector, were you in the premises at the initial encounter when Deputy Lane and Cadet Lilly entered?
I'm sorry.
Were you? You read your synopsis from your report. You indicated that you came in later. Is that right?
Correct.
The initial people that went in were Deputy Lane and Cadet Lilly.
Yes.
So you weren't there and didn't overhear any conversations that occurred prior to your being instructed to come in.
This is correct.
Thank you. I have no further questions for you.
Any other testimony, Cadet Lilly? Go ahead.
Sheriff Lane? There's no Sheriff Lane?
Is that Sheriff Lane?
Deputy Lane, he's
Deputy
the undercover detective that is actually also working with other agencies on another detail right now, so he wasn't able to be present for this hearing. But
I'm sorry, I didn't realize I made that much of a sound. I was just gonna
Please
say-
state your name.
I'm Deputy Chester.
Okay, Deputy Chester, you're saying that who's not here?
I'm sorry, the initial deputy that went in with our cadet Lily at the time, he is not present as stated with Deputy Chris Samalas earlier because he is one of our undercover agents and he works also with other agencies, so he wasn't able to be present today.
Okay. Cadet Lilly, you were there, obviously, correct?
Yes, sir.
You were served with what?
No, they passed. They didn't give me anything, sir.
And so they passed that, correct?
Yes, sir.
Okay. And who was in, when you initially went in, who was with you when you walked in the establishment? Do you remember?
It was just me and Deputy Lane, sir.
Okay. All right. Any questions for him?
Thank you. Cadet Lilly, you attempted to purchase alcohol in the front portion of the premises, the, call it, quote, liquor store portion,
Yes, sir.
and you were asked for cards,
Yes, sir.
and you indicated you did not have cards,
Yes, sir.
and you were denied service.
Yes, sir.
Okay. At that point, Deputy Lane asked to go into the bar portion of the premises,
Yes, sir.
and both of you had already said that you don't have cards. Is that right?
I didn't have the cards.
Okay. But you were attempting to gain access to the bar when you had already been carded and failed that test.
No, I was trying to buy alcohol in front of the store, not to get into the tavern, sir.
Okay. But you two were together and you asked to have access to the tavern portion of the premises and you were denied, having already been refused service because you didn't have a card.
Only he was the one that asked.
I'm sorry, I didn't hear you.
Only he was the one that asked, not me.
So he's asking for access with you standing there and you already don't have a card.
Yes, sir.
Okay. Thank you. I have no further questions.
I clarify that he wasn't going back, that he didn't ask to go back. So that clarified your questions?
Yeah.
Okay. Go ahead. You have argument now?
Okay.
Yeah, you have argument. Go ahead.
Okay, I'll move to dismiss, but if you deny it, I have the witness who was here. And basically what we know so far is that a cadet came in to do an underage buy. He was asked for cards. He was denied service. And then the two individuals standing there are trying to get back in the bar. And according to the understanding from the cadet and the report is that they said the bar is closed. Well, that's a pretty easy way to say, you're not getting in here. You don't have cards, as opposed to, and I don't know if the board's familiar with, I have a lot of patrons who, be it cigarettes or alcohol or whatever, when you tell a patron you don't have cards, you're not getting access, sometimes you're taking your life into your hands. They are mad. And you have to stand up and say, I'm sorry, you don't get in. So it's just easier to say the bar is closed. It doesn't mean the bar is closed. It means they're not getting in. So I would move to dismiss.
Okay. At this time, deny your motion. I would like to hear your clients
Sure.
testify if that is the case and if that is the reason.
Thank you. Call Mr. Sean Johnson.
Yes.
Raise your right hand, sir.
Swear or affirm under the penalty of perjury that the answers that you give and the statements that you make will be the truth, the whole truth, and nothing but the truth?
Yes.
And can you, whoever's going to speak, can you spell your name?
Sean Johnson. J-O-H-N-S-O-N.
Thank you. Mr. Johnson, how long have you worked at the Fireside North?
About over 6 years.
Okay, and what is your position there?
Manager.
Okay, so you were present on Wednesday, April 8th, 2026 at approximately 8:34 p.m.?
Yes.
And were you the only person working that evening?
No, my uncle had just left.
Just left, okay. All right, and then before I get into the encounter with Cadet Lilly, prior to this time, is Wednesday a delivery day?
Yeah.
Okay, and what kind of delivery did you get?
Alcohol.
From what company?
It was Breakthrough.
Breakthrough, okay. And about what So this incident, the sheriffs came in at 8:34. What time did you get the delivery?
Delivery probably came around like 5.
Okay. And did you stock did you stock
Yeah.
the alcohol that came?
Yeah.
What did you do with the boxes?
Set them on the counter.
And what was your intention after you set the boxes on the counter?
When I got slowed down, when I slowed down, I was going to always do.
Okay.
Yeah.
And you break the boxes down?
Yeah.
And
we
where
break
do
them
you store them for trash?
We set them by the door. We set them by the door until the night, and then we take them out.
In the morning?
No, we try to take them out at night.
Okay. Very good.
Yeah.
And you hadn't gotten to that yet?
No.
Okay. So now tell me, you were at the counter, and who came up to you and tried to order alcohol?
It was, I don't even remember him. I don't remember him. But it was a light-skinned lady and a light-skinned guy.
Okay. And what
Because I
happened?
don't remember him.
Okay. And what happened next? What did you say, or what did you do?
Well, I was already a little frustrated. And when they asked for to get alcohol, I said, "Do you have ID?" And they told me, "No, they don't have ID." So when they asked about the bar, I was like, "No, we closed." You know, I said, "No, y'all can't get it. We done. How y'all trying to get in and y'all already asked for the ID?" And that's how it went.
Thank you.
Were you in fact closed?
Huh?
Was the bar area closed?
No, we always open.
Okay. Right. And you said you don't remember this cadet here? with the
No, I'm
glasses?
not sure if I remember that one.
Okay, so you don't remember telling him that, you don't remember him ever asking to go back into the tavern or anything like that?
I remember somebody asking.
It wasn't him.
I'm not sure. I don't think it was him.
Questions, Commissioner?
No questions.
No questions?
I have a question for the cadet. Did you hear the conversation or no? The conversation about going back to the tavern area? Were you privy to that at all or no?
I'm pretty sure I heard Deputy Lane asked if he can get into the tavern.
Pretty sure. Yeah, it's okay if you didn't, you know. Yes or no? Did you hear it? Do you remember hearing it or?
I don't remember.
Okay. All right, I have no other questions.
Nothing further. I renew my argument. The bar was open. Somebody got denied access for cards, and it doesn't mean the bar is closed. It just means you're not getting back there.
Okay. Based on the charging documents, testimony given, and evidence entered in the proffer that was made, I do agree with you and don't find a violation of Rule 4.2024B, prohibited activities by a license type, given that evidence that was presented today. So I find that
I concur with the chairman. I do not find a violation of Rule 4.204B, prohibiting activities by license type, and do not find a fine.
I'm in agreement, only because Deputy Lane is not here to offer testimony. But based on the information that was presented and the testimony given by the manager, I do not find a violation of Rule 4.204B, prohibitive activities by license type.
and Commissioner is right on point, because we do not have the person that was there that can testify to that. Thank you very much, Ms. Russell.
Exhibits for the record. Board Exhibit number 1, violation report, Inspector Bass. 2, photo.
All right.
Thank you so much.
Good luck.
Brian Lawrence, The Avenue K&B LLC, trading as The Avenue Kitchen and Bar, 911 West 36th Street. Class B beer, wine, and liquor license, violation of Rule 4.011, sales to minors on March 2026. Violation of Rule 4.011, sales to minors on March 2026, and violation of Rule 3.081B, sanitation and safety on March 2026 for patrons smoking hookah inside the establishment. Please come forward.
So the licensee was unable to appear today. A manager appeared. So we will be reserving them a summons to reappear.
We're going to be reserving the summons on the corporate party. So we're not going forward with that case today. Going to the next.
Ho K. Lawler, HBS Enterprise, Inc., trading as Sugar Hill Tavern, 2361 Druid Hill Avenue, Class BD7, beer, wine, and liquor license, violation of Rule 4.011, sales to minors on April 8th, 2026. Violation of Rule 4.20B, prohibited activities by license type on April 8th, 2026, failing to open the tavern area for on-site consumption when the packaged good area was open and operating. And finally, violation of Rule 4.075, open containers in legal possession and consumption of alcoholic beverages on April 8th, 2026 for a patron consuming an alcoholic beverage directly in front of the licensed premises. Please come forward.
Thank you, Stephen W. Fogman, on behalf of the licensee, Ho.K. Lawler. Denial just for the purposes of a brief motion. Thank you.
Yes, go ahead.
Well, I need to make sure my facts are straight. So if they could start the evidence. I mean, I'll make my motion, but I just want to make sure I got my facts straight. That's all.
Okay, so you want us
yeah,
to go forward, and then you make your motion
we'll need
after?
it anyway. Yeah, thanks.
Go ahead and
Inspector McCullough, Baltimore City Liquor Board. On April 8th, 2026, approximately 8:08 p.m., myself, Inspector Bass Myers, Chief McGinnis, along with members of the Baltimore City Sheriff NSU Department, went to the above location to conduct underage BD7 operation. Undercover Sheriff and Cadet Lily went in and asked entrance for the tavern. The employee behind the glass advised the tavern was closed. Sheriff Cadet Lily then purchased 200 milliliter of Smirnoff vodka for $5 using a departmental marked $20 bill from the packaged good window. The undercover sheriff and cadet exited the establishment and advised the team of the buy. While entering the establishment, I witnessed the patron sitting on the steps drinking beer from a can and smoking a cigarette. The patron saw me taking pictures. He got up and entered the bar while still smoking and drinking. We announced ourselves and advised the employee identified as Jonathan Smith that he sold alcohol to an underage cadet and that he denied the sheriff entry to the tavern area. No seats were in the package area, and the patrons are never told to leave the establishment. I also advised the patrons that they could not sit on the steps drinking, nor could they smoke or drink in the packaged good area. I advised the violation would be written, and we left without incident.
Thank you. One question. Undercover sheriff is not here. Okay.
Correct.
Thank you. All right. Brief move to dismiss. No ability to confront accuser. Not only in this Exhibit 1 violation report do we not have the undercover sheriff's name, Cadet Lily is not even named. So we always seem to get the accuser.
Cadet Lily is next to me.
I understand that, but nowhere is it mentioned in Exhibit 1 that Cadet Lily, Cadet Lily, I don't see his name in this entire violation report. So we have no accuser. Exhibit 1.
Let's see what this is.
And that only goes to the
I mean,
4.011.
it refers to the cadet, and you're saying
I mean,
because it doesn't say his name.
Right, which it does in all these other reports, not to mention nobody's accused him of being undercover. He's been here all day. So,
He can clarify whether it was him, at least that portion of it.
Sure.
So,
no, and it's in the notice of the hearing, and it's in the synopsis. It's just not in the violation report. That's all, Exhibit 1.
there's multiple references to the cadet and in the synopsis.
Sheriff.
So, let me ask a question, that Lily, and you're making your motion on all of the counts?
No, just
All
on the
of us?
4.011. I mean, he's the, yeah, he's the.
4.011, the
Specifically,
sales to a
it's
minor?
that
When
one-
we have the cadet that was here that was sold?
Yeah, but it's not in the exhibit. I don't have a name. I have sheriff cadet and I have undercover sheriff. I mean,
Cadet Lily?
I'm getting sleepy.
Do you remember this date?
Yes, sir.
Remember April 8th, 2026, going into this establishment?
Yes, sir.
Okay. And can you tell us, in your own words, what happened when you went into this establishment?
So me and the deputy had entered the establishment. I saw the beverage that I was looking, the alcohol that I was looking for through the window. I then proceeded to ask for that alcohol. They told me the price. I gave him the money for it, and I purchased the alcohol.
Do you have any questions for the cadet?
No, thank you.
Okay. So, any questions, commissioners?
No questions.
No questions, but just reviewing
Sure. Well, and this
the
is.
history.
I want to, make sure we're talking about the motion to dismiss
about the
here.
motion
Yeah,
right
I
now.
always hate to think
Okay.
I'm waiving everything else just by trying to keep it
Right.
concise.
I'm laser
So
focused
no.
just
Sure.
on the, on
So yes, then no questions regarding the motion.
Thank you.
I don't, I love your argument. I just don't see how the name of the cadet is necessary on the violation report, when, especially when the violation report is sufficient to allow the licensee to come to be heard today. We have the witness. Now, if the witness wasn't here, I could understand that. We have the cadet that has confirmed that the cadet that's mentioned in the violation report is, in fact, Cadet Lilly. Cadet Lilly stated on the record that he was the one that was served by an employee of the licensee. Also, as you stated before, Counsel, that Cadet Lilly is plastered all over all of the other synopses that are before us here and on the documents that were sent out. I don't have, unless you can tell me where it's necessary to have the full name of the cadet on the violation report. If you can, cite that to me, I'd be happy.
United States Constitution.
But I see it differently. Go ahead.
So
you said the United States Constitution, is that?
Yes, but I've admitted in another hearing that the Confrontation Clause, Sixth Amendment, 250th anniversary of the United States, read it recently, and may apply to criminal proceedings. So
And that person is here to confront.
yes, I want to treat all my clients fairly.
Yes.
Give them all motions. So.
So I would deny your motion respectfully.
Thank you. Not unexpected. Thank you. All right, if I may, this one's a mess, and I feel so badly for Miss Lawler because I've known Miss Lawler going all the way back to when I was in my 30s. Been around since 2003. You want me to do this now, or you want to rule first? I'm sorry. I'm just.
No, go ahead.
All right. I've known Miss Lawler since 2003. I think I see at least two where another board was involved. Maybe this is the downside to, operating a bar for 23 years. She's got a record. The biggest problem, if you look back, you see this bar was there were other violations, but she never had a 4.20 charge till 19. All right. And what happened is the bar became less popular. She's got less business. And at some point, it was not really profitable to hire a separate bartender. She moved above the bar, above the tavern, that is. And as you can see, on January 30th, 2025, she was found guilty of 4.20B. I represented her in that hearing, and we decided at that time that, the A7 was now available. The A7, I don't think was available in 19, but I certainly represented her January 30th, 2025. A7 is available. She says, I really want to do an A7. I'm getting old and nobody's coming to the bar. And, so let's just see if we can do that. And so what I did was I reached out to a council that represents the district. And the councilman says, aide says, sure, we'll be happy to introduce legislation as long as the community association supports it. So I said, great, who's the community association? I'm having a hard time figuring exactly right there. And the aide said, well, I don't know, but here's 3, and gave me emails for all 3. I emailed all 3, and all 3 said, not it, not it, not it. And nobody knew who it was. So the ball kind of got dropped or left by the wayside. She then got reoffended. June 26, 2025, I was representing her, and I said, oh man, we got to pick that up and get you that A7. She goes, well, I've got this wonderful gentleman who's going to run the bar. And so, we're not going to have that problem going forward. I said, excellent. He came here. There's a new sheriff in town. I was like, okay, maybe the problem's fixed itself because we're having this phantom community association problem trying to find a community association. So apparently it didn't work out with the bar manager. And I didn't know that, but I didn't know that. But now a year later, we're here, and no bar manager. She also had, I don't remember from the last hearing, the roof was messed up on the bar. There was water coming in the bar, the tavern inside, and so she was not going to be using that tavern anymore. So, in the absence of knowing who the community association is, we are doubling down, tripling down on making a push for an A7 in lieu of trying to find out who the Phantom Community Association is. She has begun the process of getting a petition together with hundreds, that's the goal, of signatures. And I don't want to put this in evidence. I don't want to name the council, but we want to present hundreds of signatures to, and these are all Druid Hill Avenue. These are all super close. These are neighbors. These are people who have known her for 23 years, who have used her store, her bar, her store for decades. And she's very friendly. She's been very helpful to neighbors in times of need. Nobody doesn't like her. And we're going to present that to the council. And we're going to go to the surrounding, if they'll have it, the surrounding community associations and ask for their peripheral support. But we're not going to stop until we get an answer on whether or not the bill can be introduced to convert her to A7. She's, my friend, she's like me, she's gotten older during this time, and she doesn't have the strength to run back and forth. So we're kind of at wit's end, and it's been very unfortunate that we're in this position because, I look on paper and I say, oh, come on, we got to do something about this. And certainly we do. I know the liquor board does too, but clearly something has to get. She desperately wants an A7. I wish this board, I think somebody joked earlier, could give A7 rather than the legislators. And we love legislators. They don't move unless they know the community they need that. And I can't even find out who they are, let alone get a letter of support. So we're going to try to do this another way. And this is it. I mean, it's that simple. So I apologize that I let it slip past the wayside a couple of years ago. But this is where we, in all honesty and transparency, and I think.
Okay, thank you. Commissioners, any questions?
No questions.
No questions.
All right.
Mr. Chair. Sorry, just one part I wanted to add into the record is we did respond to this property on the operation after receiving an anonymous complaint about the property being open, the tavern not being open. So this was substantiated the complaint, and I did look at the zoning really quick. It's a residential district, so it may not be eligible for an A7 as they're not prohibited in residential districts.
All right, well, that's news to me. And since the record's still open, I called Mr. Ackheimer, and he didn't know who the community association was. So but that could be a bigger monkey wrench. There is this thing called community commercial that you can upgrade, there's a new thing.
Neighborhood commercial.
Right. And so, but, once again, that's more money. That's not me. That's a planning expert. But it's just got to be done. It's just got to be done. Or we're going to be here and licenses ultimately going to, get revoked. So.
All right, based on the charging documents, the testimony that was given, proffer made by counsel, argument made by counsel, exhibits that we have on the record, I do find a violation of Rule 4.011, sales to minors. This is your, fourth time? Fourth time.
Oh, no. 19, 25.
You showed her that it is a fourth time, okay? For that violation, $3,500 fine, 30 days to pay. The second one is a violation of Rule 4.20B, prohibited activities by license type. This is, I think, arguably the second, but they're dealing with the tavern. On this one, $1,000 fine, 30 days to pay. The third one is a violation of Rule 4.075, open containers and illegal possession, consumption of alcoholic beverages, $500 fine, 30 days to pay. All of these happened, on April 8th, 2026. Commissioners?
I do find a violation of Rule 4.011, sales to minor, $3,500, 30 days to pay. Violation of Rule 4.204B, prohibit activity by license type, $1,000, 30 days to pay. And violation of Rule 4.075, open container and legal possession, consumptions of alcohol beverages, $500 fine with 30 days to pay.
If I may just say one thing, it's just gone 7 years without a sale to minor. It looks like 7 years without a sale to minor, but you've obviously factored that in. But yeah, the other thing is, we'll ask for as much time as you'll give us to pay that, 60 days.
Yes, it's fine. Yeah, 60 days.
Well, let me rule, counsel.
Oh, my God. I'm
I do find in violation of Rule 4.011, sales to minors, impose a fine of $3,500. I find a violation of Rule 4.204B, prohibited activities by license type, impose a fine of $1,000. And I find a violation of Rule 4.075, open containers and illegal possession and consumption of alcoholic beverages, impose a fine of $500. And I would make an agreement to have 60 days to pay.
Thank you.
Ms. Russell?
Medical exhibit for the record, Board Exhibit 1, violation report, Inspector McCullough.
Thank you.
Council understands,
Have a great afternoon.
point.
Thank you.
Chun Bishwakarma and Purushottam Dakal, I apologize if I mispronounced that, Narayanan LLC, trading as Aloha, 1218 North Charles Street, Class B, beer, wine, and liquor license, violation of Maryland Code Alcoholic Beverages and Cannabis, Section 12-2007A, after-hours activity prohibited in licensed premises on March 21, 2026, for engaging in after-hours activity, violation of Rule 4.14, live entertainment without authorization, on March 28, 2026, violation of Rule 3.12, general welfare, on March 28, 2026, for loud music, and violation of Rule 3.092, restroom facilities and health regulations, on March 28, 2026, for a violation of Baltimore City Health Code 9-312A. Please come forward.
For the record, Melvin J. Kadensky, representing the licensees. I think I got a 40-page note. No, sorry. We will agree to admission as to 4.14 and It was the after hours. I have to have some information on general welfare and restrooms. I'm not really sure what that violation is.
So you're only making admission to the 4.14, is that what you're saying, or?
Live entertainment, and then you have one for after hours.
We have 3.12, the general welfare one.
You, for some reason, you put down
music.
12.207A.
That's the first one.
Yeah, that's after hours.
The March 21st one.
Yeah,
That's what you're saying. Yeah.
that would be admission. Admission is to the music, but and the general welfare, I just don't know what I need some information on that, please.
The loud music, that was on March 28, 2026. That's the one you said you want to,
Yeah,
okay.
and then of course restrooms. I'm not sure what Baltimore City Health Code 9-312A. I need some clarification on that.
Are we on Aloha?
Agent, who's going to?
Yeah.
Are we
Sorry,
on
I'm just,
Aloha or
we got,
Brandis?
Aloha.
Aloha.
19.
1218 Charles Street.
Give us 1 second.
I got it. Thank you. Agent Tuttle, Baltimore City Liquor Board. On March 21st, I, Agent Tuttle, along with Agent Perez, Chief McGinnis, and the Baltimore City Sheriff's Office Neighborhood Service Unit conducted a after-hours compliance check throughout the city of Baltimore. At approximately 2:08 a.m., we began observing the establishment known as Aloha, located at 1218 North Charles Street, after receiving multiple 311 complaints indicating the establishment was open and operating after 2 a.m. While conducting surveillance, I, Agent Tuttle, observed multiple individuals entering the establishment after 2 a.m. At approximately 2:11 a.m., undercover deputies entered the establishment and were able to confirm that it was open and operating. The rest of the team were notified about these findings and subsequently gained entry into the establishment. The establishment was instructed at that time to have all patrons leave. I observed approximately 40 individuals exiting from the establishment, including 2 patrons carrying what appeared to be alcoholic beverages. Once inside, I observed drinks on the bar area, a DJ set up with turntables, mixers located near the entrance of the basement. I made contact with the operator and person in charge, Miss Natasha Penne, who was identified via her passport. Ms. Penne was informed that she would be issued a violations. All agencies cleared the establishment without further incident.
No questions.
Just you didn't issue a violation to her though.
The establishment.
Yeah. Okay. Fine. No. Nothing.
And this is admission, correct, on this one?
Yes.
So, based on, any questions, commissioners?
Yes, counsel, is your client renting out this business? Because when I pulled it up, it looks like it was supposed to be a sushi bar.
Have you
Sushi.
been there?
Sushi. No, I haven't been
You
there.
know,
I'm asking.
it's the weirdest place. It used to be a lot of Tokyo. Now, if you walk in, you go in this way, you go up half, and you go over this way, and you go down, and they have the food operation, the packaged goods. It's right near University of Baltimore, about 2
I'm
blocks.
familiar. I'm a graduate.
It's really a strange configuration. The answer is no, but when I get
They're not renting.
no,
out.
they're operating, but they're not renting to somebody else.
What did this used to be before?
It used to be called Aloha Tokyo, and then something before that. They had problems trying to get it should be in your, you know what it is? Before that,
That's where I went to law school.
you went to law school? Harvard itself?
yeah.
Yes, of course.
Maybe I did. Okay, based on the charging documents, the testimony that was given today, and the admission that was given today, I do find that there was a violation of Maryland Code Alcoholic Beverages and Cannabis, Section 12-2007A, after hours activity prohibited in licensed premises. We have a mandatory.
Well, can you hold the disposition until we do the other 2 cases and do them all at one time?
Why? Mandatory is $1,000 in this one, and 30 days to pay. I wanted to do this one and move on to the next.
Well,
Is there a reason?
I'm all right with it. That's what it says in the statute. I'm not all right with it, but I can understand. That's fine.
Okay. Well, that's what I'm making my ruling on the first one now. Commissioners?
Based off the information provided today, on violation of Maryland Code, alcohol beverage and cannabis 12-2007A, after hour activity. This is a mandatory $1,000 fine, and I would think that's 30 days to pay.
I'm also in agreement. I find a violation of Maryland Code, alcoholic beverages and cannabis, Section 12-2007A, after-hours activity prohibited in licensed premises on March the 21st, 2026. Impose a fine of $1,000, 30 days to pay.
Inspector Bass Myers, you're going to testify what happened on March the 28th, 2026?
Inspector McCullough, Baltimore City Liquor Board. On March 28th, 2026, myself and Inspector Bass Myers responded to 311 complaint, which was a noise complaint, at the location. Upon arrival of the establishment, it was open and operating. Music could be heard from the establishment. We went in and advised the DJ to turn the music and the bass down. I first abated the complaint and we left without incident. But upon further investigating the license, the establishment is not allowed to have live entertainment. McCullough. Gotta get used to it. Inspector McCullough then wrote a violation for live entertainment along with the 311 loud noise.
When you said that, when did you hear the music? When you opened the door or you were on the street?
When we was parked from across the street.
All right, and you're on Charles Street.
Yes.
And it has a lot of ambient noise on Charles Street, traffic, so forth.
No, it was like in the wee hours of the morning.
So what was the decibel reading for?
I don't have a decibel reader.
You don't have?
Counsel, you know.
No.
You know decimal readings. All right, that's a secret.
But the windows were vibrating, and the DJ was sitting right in front of, his DJ booth was right in front of the window.
But you said, who'd you get the complaint from?
311.
But you don't know where it came from, though?
No, sir.
Yeah, no further questions.
Okay. Go ahead.
Is that it? No, are they finished? Yeah, I don't know if there are other. Well, regarding that, I would ask that the health violation be dismissed. I don't see any testimony as to that. Regarding the other general welfare and live entertainment, we agreed to the live entertainment. Now, in response to Commissioner Thomas, what had happened is, you've seen this before, you have these promoters that come around and they want to come in, they want to help you.
So they
help
say.
you right out of business. That's what they want to do. Unfortunately, they haven't been before the board. They're new licensees. Thank God there was no hookah there. But once they got into it, they got rid of all of that. No DJ. They just got rid of the people that were there. And they know that they can't do it. And you'll probably see this promoter pop up somewhere else again. They take as much out as they can until they get stopped, and they go from there. The particular area, they could apply for a conditional use, but that's not before you right now. So they have never been before the board before. They've been licensed, has been there since transferred to them July 2023.
So you always say something about the violation of Rule 3.092, restroom facilities and health regulations. Is that what you were referring to, Counsel?
That's the one, yeah, that's 3.99. There's no testimony as to that.
Which is the violation of Baltimore City Health Code 9-312A, which you know is the commercial enterprise broadcasting over loudspeaker.
But
Heard
how's that
more than
different?
100 feet
I'm sorry.
from the boundaries.
How's that different than general welfare? Isn't it the same?
This one. And
That's what I'm saying. You have
the
to-
second one. Go ahead. I'm
No,
listening
the
to your
loud
argument.
music has to go together with 312. You can't, which one you can't. You can double bang them, but I'm saying you really shouldn't. They should be, merged regarding that.
Okay.
Okay, that's fine.
That's clear. And I may agree with you on that. Based on the charging documents that we have on this case, the testimony that was given and proffer made by counsel, I do find a violation of Rule 4.14, live entertainment without authorization. On that one, hold on one second, let me look at it. I do issue a fine of $500 on that one. On the violation of Rule 3.12, general welfare, I do find a violation of that rule and issue another $500 fine on that one. And I do find a violation of Rule 3.092, the restroom facilities and health regulations. I'm not going to issue a fine on that one, though, since it is dealing with the loud music, which we've already fined you on that one. So a total of $1,000 fine with 30 days to pay.
I concur with the chairman on violation of Rule 4.14, live entertainment without authorization, a fine of $500, and violation of Rule 3.12, general welfare, violation of $500. For violation of Rule 3.092, there's no fine amount giving with 30 days to pay.
I am in agreement. I find a violation of Rule 4.14, live entertainment without authorization, impose a fine of $500. I find a violation of Rule 3.12, general welfare, and impose a fine of $500. I do find a violation of Rule 3.092, restroom facilities and health regulations, and I will concur with the chairman that we will not find you at this time with that.
How much is that microphone? We may need to fine for council breaking our
Let me look into that.
No, you want to hear it, not look into it.
I'd like to call exhibits for the record. Board Exhibit Number 1, Violation Report, Agent Tudhope. 2 through 3 photos. 4, Violation Report, Inspector McCullough.
Thank you. Okay, final case for the day. Deborah D. Wacker and Susan K. Witten Hawkins, Hartford Road Group LLC, trading as Brandon's Pub, 5516 Hartford Road, Class BD7, beer, wine, and liquor license, violation of Rule 4.14, live entertainment without authorization, for having live entertainment without permission on April 24, 2026. And violation of Rule 3.081B, sanitation and safety on April 24, 2026, patron smoking and vaping inside the establishment in violation of the Clean Indoor Air Act, and violation of Rule 3.12, general welfare on April 24, 2026, for being over capacity. Please come forward.
Good afternoon. Can you guys please raise your right hand if you're going to testify?
Do you swear to affirm under the penalty of perjury that the answers that you give and the statements that you make will be the truth, the whole truth, and nothing but the truth? Can you answer verbally?
Oh, I do.
And ma'am, your name is?
Susan Hawkins.
Okay, and will the gentleman next to you be speaking, or is he just standing for?
He's going to be speaking.
Okay, can you state and spell your name?
My name is Emmanuel Neal. IMMANUELNEALE.
All right. So you see that we have, 3 violations on the docket today? Is this, and you've probably heard a few of the other cases as you sat here. Do you guys want to make an admission that you did violate and explain what happened and ask for mitigation, or do you want to challenge those violations in general?
I do want to challenge the capacity part.
Okay. That's the last violation. The 3.12 is a challenge, but the other 2 you're going to make an admission to.
And I don't see where anybody was actually vaping or smoking.
Okay. Well, you'll hear the testimony, and then we can decide that, okay? Thank you. What's your name?
Emmanuel
Emmanuel, what's your last name?
Neal.
Emmanuel Neal. Okay, go ahead.
Good evening. I'm Agent Tuttle, Baltimore City Liquor Board. On April 24th, 2026, the Social Club Task Force did an inspection that was initiated by BPD Northern District due to concerns regarding overcrowding and outdoor alcohol consumption. I, Agent Tuttle, made initial contact with the security guard positioned at the entrance and asked him for the capacity. He was unable to give me that capacity or inform me what the capacity was. Upon entering the establishment, I conducted a visual head count estimating approximately 100 people present, excluding staff and security personnel. During my time inside, I observed multiple patrons actively smoking and vaping inside the premises. Additionally, I observed a DJ operating a full setup, including turntables, a mixer, a laptop, microphone, speakers, indicating live entertainment.
Was that part of the music? Agent, go ahead and finish it.
A review of the establishment permits revealed that Brannan's Pub had an approved fire capacity of 95 people. Furthermore, the establishment's liquor license does not authorize live entertainment. I then made contact with the manager, Ms. Renita Massey, who was identified via her Maryland driver's license. I informed her of my observations and told her that she was exceeding her occupancy limit and was conducting unauthorized live entertainment. She was advised a violation would be issued and instructed immediately to cease live entertainment activities and to maintain occupancy within the approved capacity at all times. The task force concluded our inspection and we left the establishment without further incident.
You can ask any questions you want now.
Okay, so we were told that we can't have an actual DJ, but you can have a setup with a playlist, long as we don't have anybody physically standing there mixing. So what that just showed is nobody behind there mixing. You have a setup and a playlist going on. Other than that, I was like, well, you said you walked through and did a visual head count. You can count 100 people in a dark space.
Did you answer the question?
Yes, I did a head count as best I could with people moving around, and that's what I came to. And as far as the DJ, the individual with the microphone was walking around the bar. Further on that video, you can actually see the individual holding the microphone, walking around the establishment as the hype man.
Mm-hmm. So you said you did a visual.
Yes, sir.
Yes, you could. So that's where you're.
That's why it's approximate.
Yeah.
I can't do an exact.
So you don't know the exact. You don't know the exact number.
I did an approximate where I counted about 100 people, and I didn't include the employees, or I think there was 3 to 4 security guards at that time.
But my question was, you said approximate. So there's a capacity of 95.
Yes.
So kind of need to know, do you know if it was exactly over 95 or not, or how did
I
you do your
walked through
count?
slowly counting people, but people are moving. And I stopped when I got to the DJ and did like a quick visual count, and I had got to the number 100 by then.
You say approximate because they're moving. You don't know
Because
if you're
people are
double
moving,
counting
and
or-
I can't be 100% sure that there were more or less people inside.
Okay, you're not 100% sure. Okay. Any questions to follow up on mine?
The only other thing I was talking about was as far as the vaping and smoking. We try our best to enforce that. I do have signs posted. They're posted front, back, everywhere. I have the security walking through, telling people to take their vapes outside and everything like that. It's never been smoking in bars in years. The vaping thing just started. So for somebody actually smoking in there, it's not happening.
Okay. Anything with the vaping, smoking?
I saw someone with a cigarette, what appeared to be a cigarette, and then I saw another 2 individuals with vapes actively vaping at the bar area.
you have any other arguments or mitigation? You can say whatever you want.
Just moving forward, we had our sit down with our security team. We tightened up. We added more non-smoking and vaping signs. As far as the outside, that's becoming a big problem. So we have Baltimore City that sits out there. They do nothing. You got people that's constantly pulling up in cars and getting out their cars, and they want to stand outside like it's the park and drink. My security comes outside to push them away from our front. At the end of the night, I can find myself going out there picking up cups that we don't carry in our bar, picking up bottles that's out there. But if Baltimore City is not going to enforce them to stop it, I don't know what else we can do, because when my security gets out there, after a while, I tell them, come back in. Let's finish up in here. We did all we could.
Yeah, if you need some help, any resource, I don't know, because that sounds like it's outside of your premises.
But
That's not even one of the violations.
It was
that
one.
you have.
It was on the paper that we received. That it was an overwhelming amount of people outside drinking.
I mean, I do commend you for trying to figure that out, because you're going to have to figure that out, because that's going to bring more and more attention to your establishment. It's going to make our agent come out there and see what's going on the inside, see if you're part of that process. There are a number of establishments in the city that do have large crowds outside, and it puts a bullseye on them. And if you can't control the people coming in and out of your establishment, that's one thing. If it's not from your establishment, you need to be able to bifurcate that whole situation to make sure it's not connected to you. But it's good to be upfront about it and even discuss it openly with us. And if we can help in any way we can. I am ready to make a ruling on this based on the charging documents, the testimony that was given today, the exhibits with the music that was playing. While Agent was speaking, I do find a violation of Rule 4.14, the live entertainment without authorization. You can talk to us about the rules, how to make sure that you're following the rules, and if you need to make a change, let's go ahead and get that change made so you're not in front of us again, okay? On that one, I'm only going to issue a $250 fine. I don't think you've had one before. You've just had a sales to minors before, and seems like you guys have fixed that issue.
Yes.
Yeah. The second one was the sanitation and safety. You got to watch that smoking. People can't sit in there and smoke. I know it's hard when you have a crowd, but another $250 fine on that one. But I'm glad that you since you did put those more signs up, that's why I'm going to give you a nominal fee on that. I don't see the violation of Rule 3.12, general welfare, only because the testimony stated that the exact number was not identified. And yeah, so I can't find a violation of Rule 3.12, general welfare in this case right here. 30 days to pay on both of those fines, okay?
I concur with the chairman on violation of Rule 4.14, live entertainment without authorization, a $250 fine. I do find a violation of 3.081B, safety of a $250 fine. I will recommend that because you see that she did approximately of how many people that she thought was there, that the establishment, you guys should take some role in figuring out how, when you at your capacity level, to work internal with making sure that that doesn't become a fine, since, the chairman ruled in no fine for general welfare with 30 days to pay. Thank you.
I also find a violation of Rule 4.14, live entertainment without authorization, impose a fine of $250. I find a violation of 3.081B, sanitation and safety, and impose a fine of $250. I'm also in agreement that I do not find a violation of 3.12, general welfare. I would make a suggestion that you have clickers, your security guards. They have clickers, and then they manage the flow in and out. I I want to commend you on stating your case, and certainly I think you are trying to do the right thing as a licensee, and so we hope that you continue.
And just because we didn't find a violation of the last one doesn't mean that you weren't over 95. It means that the case just wasn't proven. So that means, as my commissioners have said, you have to be on it to make sure that doesn't happen, okay?
Okay.
You got it? All right.
Thank you.
Ms. Russell?
Because it is for the record, Board Exhibit Number 1, Violation Report, Agent Tudhope, 2, photos.
Thank you, guys.
There being no further business before this board, the board is in recess until Thursday, June 4th, 2026 at 10:30 a.m. We are adjourned.
It was for you.